Everybody. I'm not formally. Morning, everybody. It is now 9:30, which means it's time for the inquiry to resume on its 22nd and what should be its final day. The programme today is intended to continue with closing submissions, firstly on behalf of the two district councils and then on behalf of the applicant. As is inevitably always the case, there are a number of documents that we need to check at the start of the day. I just want to quickly run through those to make sure everybody is aware of what they are. Firstly, there's an update been received from Anglian Water, who put in an objection. The gist of that is they tell us that there have been discussions continuing with the applicant. They anticipate agreement being reached, but that would be after the inquiry has closed. Assuming agreement is reached, they will then proceed to withdraw their objection and advise the Secretary of State accordingly. The closing statement was submitted by PX Farms, who they'd been given the opportunity to appear, as which other parties have taken up. They somewhat unusually have submitted a statement instead, but we've accepted that as they are a statutory objector. Then there are some additional factual documents from Mr. Sullivan, who appeared back in October on speaking about transport matters. They simply relate to matters that he raised when he presented oral evidence at the inquiry. There's a few bus timetables and a couple of photographs of St. Neots Station. Given that that simply relates to what he spoke about, that has also been accepted. And the final point on documentation is the documentation concerning the order itself. I think the bulk of that is now on the inquiry website. The subsequent explanatory memorandum may just be being put up, but that has been received. And I think the plans may have to go up as yet, but I think we have put all that documentation in hand. I think there were certain outstanding matters which arose as a result of the sessions yesterday, which are the schedules of plans. But can you just confirm, Mr. Cameron, that as far as you're aware, everything to do with the order has or is being submitted?
Has or is being, yes, sir. You'll remember when discussing the order, you asked about the deposited plans. We're drawing up a list of the deposited plans, which will be submitted. You also asked about the wording in work number 1, why the word busway was used rather than guided busway. And I will, I'm just waiting for instructions on that, and I will deal with that at the beginning of just before the beginning of the closing.
Yes, thank you.
On the other drawings related to conditions, Mr. Henderson will deal with it.
Yes, sir. So in respect to the conditions, you will have received, or the programme officer will have received this morning, a number of things. The first is a letter from my instructing solicitors dealing with the question of consent to the pre-commencement conditions if it's required.
Yes.
We say it's not, but you have our consent anyway. The second is an updated list of plans, being those plans within Schedule 2 of CD 114, the request for the direction under Section 932A. That's now been updated with the latest revision numbers where necessary. And the third thing will be, and you have received, or the programme officer has received, a note from Carter Jonas and Mr. Roberts yesterday dealing with the two conditions that we said we'd suggest an alternative text, B and G, firstly, and secondly, the detailed design. So that they've been put together in a single note and provided to you.
Yes.
And then the fourth and final thing, which came simply in the cover email because it's a two-liner, is our confirmation on the application of Section 90 of the 1990 Act. So in respect of conditions, subject to the point on the vets, which we'll produce a letter for, you now have everything that you should have been expecting from our list yesterday.
Thank you very much. Is there anything else at all, Mr. Cameron, that you wish to raise?
No, sir. In relation to the written closing on behalf of PX Land, we will respond in our closing, but I will make some oral additions to deal with that.
Okay, thank you. Mr. Parker, do you have anything?
Nothing.
Right. Anything else? In that case, we'll get underway, please, with the closing submissions on behalf of Cambridge City and South Cambridgeshire.
Thank you, sir.
Mr. Robkin-Wright, please.
Just on documents before I begin closing. You had asked for confirmation regarding the council's committee meetings on the emerging local plan, and just to confirm that will be sent through after the inquiry has closed. I understand that can be sent on the 5th of December because the final meeting is on the evening of the 4th of December. So that will be provided, just confirming whether there were any changes as a result of those meetings to the emerging local plan. Ms. Teravingo is just going to hand around the closing statement.
Thank you very much. And just before you get underway, I'm inevitably keeping a fairly close eye on the clock today.
Yes.
I think you said about 3/4 of an hour?
Yes, 17 pages, so I'm hoping that I can
do
it.
When you're ready then, please.
Thank you. The Council's position remains, as in opening, that the scheme is critically important to the delivery of adopted development plan policy and the future expansion of Cambridge in line with their spatial strategy, demonstrating a strong strategic need for the scheme. Taking into account the mitigation measures which will be secured through the order and planning conditions, the relatively low level of residual planning harms is outweighed by this need and by the significant public benefits of the scheme. Notably, the Council's case on strategic need has not been challenged by any party to the inquiry. Furthermore, objectors generally agree with the pressing and compelling need for, at the least, a scheme to improve public transport between Cambourne and Cambridge, and with the need for such a scheme to improve journey times and reliability. In the words of Mr. Littlewood, it is largely agreed that something has to happen. There is therefore a clear justification for making the order and granting deemed planning permission for the scheme, rather than waiting for some hypothetical future solution or letting the perfect be the enemy of the good. As indicated in opening and confirmed in evidence by Mr. Kelly, the Council's role in this inquiry has been as local planning authorities responsible for the areas affected by the scheme, notwithstanding the separate role of the leaders of the councils as voting members of the GCP Executive Board. The Council's decision to support the scheme in this inquiry process has been taken independently of their involvement on that board and on the basis of a thorough review of the environmental information supporting the scheme and extensive discussions with the applicant regarding mitigation and planning conditions. Following that review and subject to the agreed planning conditions, the councils rely on the applicant's evidence to the inquiry regarding the acceptability of the environmental impacts of the scheme. While the scheme will result in some residual planning harms, in particular to biodiversity and trees, landscape, best and most versatile agricultural land, heritage assets and the Cambridge Greenbelt, noting the limited scale of those harms and the accordance of the scheme with the Council's spatial strategy and strategic transport policies, the scheme complies with the adopted development plan read as a whole. The less than substantial harm caused to heritage assets is outweighed by the significant public benefits that the scheme will bring. Those benefits also amount to very special circumstances which justify inappropriate development in the Greenbelt. With regard to the business case for the scheme, the councils do not make any separate case or tender any evidence, but adopt the applicant's position as presented to the inquiry. However, the councils emphasise that the business case, including the benefit-cost ratio as assessed as part of that case, while pointing in favour of the scheme, is just one factor to take into account when determining whether the order should be made and deemed planning permission granted for the development comprised therein. Overall, having regard also to the wider context, including the drivers for growth and the continuation of the direction of travel in the emerging Greater Cambridge Local Plan for the Council's long-standing spatial strategy, there is a compelling case for making the order. Critical growth drivers for the scheme. As explained by Mr. Kelly in evidence, there are a number of critical growth drivers for the scheme which demonstrate why it is a key component of the spatial strategy for Greater Cambridge, both as set out in the adopted local plan and in the emerging joint plan for Greater Cambridge. An infrastructure-led or infrastructure-first approach underpins the spatial strategy in the adopted and emerging plans and is key to ensuring the sustainable growth of Cambridge while retaining the aspects that make it so attractive to residents and workers, including its identity as a compact, historic city with a robust greenbelt edge. As agreed by Mr. Lee and Mr. Littlewood on behalf of CPPF and CPC, this approach aligns with the vision-led approach now mandated by the MPPF. The vision-led approach includes planning patterns of growth with existing and planned transport infrastructure in mind and ensuring a genuine choice of modes for future users of development. Transport infrastructure, including public transport and active travel provision, should now be deployed proactively through strategic measures such as the scheme to deliver modal choice and mode share, rather than reactively responding to the assessment of transport impacts of development. In Greater Cambridge, the infrastructure-led approach, including the development of transport infrastructure in the Greenbelt, is crucial for ensuring the sustainable growth of Cambridge while still retaining the overall openness and permanence of the Cambridge Greenbelt by avoiding the need to release Greenbelt land for housing development. As Mr. Kelly explained, in developing the adopted local plans, Greenbelt assessments were undertaken to identify whether any further Greenbelt could be released without harming Greenbelt purposes. The conclusion of that exercise was that there should be no further Greenbelt releases, but that the next most sustainable option was to concentrate growth in a constellation, in his words, of new settlements beyond the Greenbelt, and to make them sustainable by ensuring those settlements reach a critical mass and are supported by a radial network of sustainable transport routes. On behalf of CPPF and CPC, Mr. Littlewood fairly accepted that without such a strategy of developing new settlements outside the Greenbelt, there would be a need for further Greenbelt releases at the edge of Cambridge. He also accepted that high-quality public transport connections from those settlements to services and employment and in Cambridge, which are capable of supporting long-term growth, are necessary in order for such a strategy to be sustainable and not overly car-dependent. That is not a strategy that CPPF and CPC take issue with or say should be changed. An infrastructure-led approach also shapes decisions and behaviour for residents and other users of new development from the very beginning, informing choices about where they live or work and whether they need to own a car to do so. It thereby avoids the need for the more difficult exercise of changing behaviours once people have become accustomed to travelling to or from their place of work or home in a particular way. The adoption of an infrastructure-led approach in Greater Cambridge is evident from and has been informed by the TSCSC, which includes at Policy 1 a strategy to provide sustainable transport capacity in and around the city between key employment areas and to where people live and access services, through a high-quality passenger network of bus, guided bus and rail services, and comprehensive pedestrian and cycle networks. Policy 3 emphasises that additional travel demand on the constrained transport network of South Cambridgeshire and into Cambridge should be accommodated wholly or in part by passenger transport services on the main radial corridors. The importance of a long-term comprehensive solution for inbound and outbound services on the Cambourne to Cambridge corridor as part of this strategy is recognised in the supporting text of Policy 8. As Mr. Kelly explained, the approach taken in the TSCSC in terms of the ambitions for changes to mode share, reducing private car use, transforming bus travel, and enhancing public transport along priority corridors remains relevant today. As well as informing adopted development plan policy, this approach has been taken forward in the extant LTCP produced by the Combined Authority for Cambridgeshire and Peterborough. For example, the LTCP emphasises the aim of encouraging a shift from the private car to public transport, thereby reducing car dependency and helping to meet net zero and our target of reducing car mileage by 15%, and explains that buses form a fundamental component of our sustainable transport network for journeys beyond distances that people can use active travel, allowing people to access key services, training and employment opportunities. The Mayor has committed to delivering the growth envisaged in the local plan and that anticipated by the formation of the Cambridge Growth Company. As stated by Mr. Kelly and recognised in the LTCP, a transformation in the experience of bus users is required to reduce the level of private car use in the context of that anticipated growth. The impact of not taking an infrastructure-led approach and failing to approve the scheme in advance of further proposed growth in the Cambourne to Cambridge corridor is a risk to the ability of Cambridge to grow successfully without increased congestion and carbon emissions, negative effects on employees and existing residents' quality of life, and reduced attractiveness of the city to businesses and employers considering whether to invest in Cambridge. If it is not possible to develop a transport-led solution for additional housing, it may be necessary again to explore releasing sites on the edge of Cambridge with concomitant environmental and greenbelt harm. Delivering the spatial strategy. As well as shaping future growth and behavioural change, the scheme is also essential for delivering the existing spatial strategy and unlocking development provided for in the adopted local plans, including a large proportion of affordable housing, in a context where the opportunity to expand the city further without harm to the Greenbelt has been largely exhausted. In particular, local plan allocations at Cambourne West and Bourne Airfield have been developed having regard to the wider ecosystem of public transport in Cambridge and the opportunity for sustainable connections between where people work and where they have their homes. The scheme would enable the realisation of these allocations, which have now been granted planning permission, in a sustainable way. The assumptions and modelling that underpinned the development of those local plan allocations are based on a need, in line with the spatial strategy and the objectives of the TSCSC, to drive mode share away from private car use. Mr. Kelly's conversations with local developers confirm that the certainty, or lack thereof, of delivery of new transport infrastructure to support residents of those developments is central to their consideration of how quickly they can deliver new homes in accordance with the plan allocations. It is common ground between the applicant, the council, CPPF and CPC that the allocations at Bourne Airfield and Cambourne West are an essential part of the spatial strategy in the SCDC local plan and are based on and consistent with the scheme coming forward, albeit CPPF and CPC argue that policy requirements can be equally satisfied by alternative public transport improvements along the A1303 corridor. With regard to Bourne Airfield, the wording of the site allocation and the terms of the planning permission granted in accordance with that allocation show a clear dependency of development on the scheme. Policy SS7 makes specific reference to requirements for significant improvements to public transport, including the provision of high-quality bus priority measures or busway on or parallel to the A1303, which reflect the need to effect a mode shift deriving from the objectives in the TSCSC and the evidence base underpinning the SCDC local plan. The description of development in the planning application refers to the incorporation of part of the wider strategic transport corridor represented by the scheme, indicating the scheme's importance to the determination and approval of the application. As Mr. Kelly explained, in the light of strong local opposition, the importance of the scheme being able to secure a mode shift towards use of public transport was a significant component of the assessment of the planning merits of the application for permission at Bourne Airfield, and the mitigation of its transport effects. That is reflected in the imposition of Condition 13 on the permission, which prevents the occupation of more than 500 dwellings until the scheme or an equivalent scheduled rapid mass transit passenger carrier service is delivered. The reason for the condition refers to Policy SS7 and the need to make significant improvements to public transport infrastructure. The view of the Highway Authority when the application was submitted was that no development should take place before the scheme had been completed, but following significant engagement with the applicant for that permission and its consultants, and a number of mitigation measures proposed through the accompanying Section 106 agreement, the Highway Authority's position was revised to a 500 dwelling limit. Acknowledging the concerns of the local community, members of the Planning Committee rejected a suggestion made in the officer's report that the condition imposing the 500 dwelling limit be subject to a facility to agree to remove or vary that limit with appropriate further evidence. Those objecting to the order have raised the possibility of an application being made pursuant to Section 73 of the 1990 Act for the variation or removal of Condition 13, without providing any evidence that might support such an application or evidence that indicates whether such an application would be granted. Whether a Section 73 application would be granted would be a matter for the judgment of the Council when the application was made, and would depend on the applicant demonstrating that the condition or the 500 dwelling limit was no longer necessary. Given the reasoning behind the imposition of the condition and the wording of Policy SS7, as Mr. Kelly explained and Mr. Lee agreed, it is unlikely that any application to remove the condition would be successful. A package of measures is already required by the Section 106 agreement accompanying the Planning Permission to mitigate effects caused by the occupation of the first 500 dwellings. Varying the limit upwards would require a substantial amount of further evidence, which would be subject to rigorous examination by the Highway Authority and local residents, and would require the local planning authority to be confident that the environmental and transport effects had been sufficiently quantified and were capable of effective mitigation. In the absence of any such evidence being put forward by any party to this inquiry, any suggestion that the condition could be varied is entirely speculative. The development at Cambourne West also displays a clear dependency on the scheme. Policy SS8 of the Council's plan includes a requirement for high-quality segregated bus priority measures on the A1303 between its junction with the A428 and Queen's Road, Cambridge, and direct segregated high-quality pedestrian and cycle links to West Cambridge, Papworth, Everard, Caxton and Bourne. These requirements were taken forward in the Section 106 agreement for Cambourne West, which includes obligations requiring contributions to be provided towards the scheme at specific trigger points based on the number of units occupied, the delivery of a segregated bus and active travel link between the Bourne Airfield development and Cambourne to enable the scheme to continue onwards to Cambourne, and highway improvement measures to facilitate bus movements within Cambourne and the Cambourne West development. That infrastructure is both necessary to deliver successful development at Cambourne West and could not have been taken into account by the local planning authority as a reason for granting planning permission if it were not necessary to make the development acceptable in planning terms, pursuant to Regulation 122 of the Community Infrastructure Regulations. Mr. Kelly indicated that the obligations were imposed on the basis of the objectives of the at that time draft local plan and the adopted transport strategy, in order to facilitate the required higher quality public transport journey into Cambridge from the new settlements, to encourage mode shift, reduce congestion, and resolve the particular challenges on the Cambourne to Cambridge corridor. He further explained that when permission for Cambourne West was granted, there was a clear commitment to the scheme under the City Deal and an expectation that the scheme would be advanced and implemented in line with the triggers for contributions to the scheme in the Section 106 agreement for Cambourne West. Innovation clusters. As Mr. Kelly explained, Cambridge has an innovation ecosystem which depends on high levels of connectivity to enable people-centric or in-person encounters to drive economic outcomes. Its success as a leading international centre for science derives from those in-person encounters, which include facilitating working relationships between students and early career researchers, Nobel Prize winners, academia and business. That in turn relies on a supply of talent and the ability to accommodate that talent, including more junior academics and professionals, within an easy and reliable commuting distance of the main science hubs and employment centres in Cambridge. For that reason, the approach of assessing the need for development in Cambridge has, uniquely, been to start with an estimate of the need for jobs based on economic growth drivers, and to then seek to allocate land for housing to support the forecast number of jobs. The focus on a need to support clusters and in-person encounters is explicitly recognised in the NPPF. It is not, as Professor Booth sought to argue on behalf of CPRE, outdated or obsolete following the COVID-19 pandemic. Similarly, academic and business floor space at West Cambridge should not, as some objectors sought to do during the inquiry, be dismissed as an irrelevant or minor employment location by comparison with, for example, the Cambridge Biomedical Campus or the Science Park in North Cambridge. Following the grant of permission for 400,000 square metres of academic and commercial floor space at West Cambridge, it is pegged as a substantial innovation district and was described by Peter Freeman as one of the biggest growth areas for employment in Cambridge. Mr. Littlewood accepted that it was likely to become an increasingly important employment location in Cambridge. The emerging plan recognises the relationship between the scheme and the West Cambridge development and envisages that the scheme will influence further growth at West Cambridge. The relationship between employment development at West Cambridge and the scheme is further strengthened by the large increase in housing proposed at Cambourne in the latest version of the emerging Greater Cambridge Local Plan, which in turn increases the potential for employees at West Cambridge to live in the Cambourne to Cambridge corridor, using the scheme to travel to work, and for enterprises developed on the West Cambridge campus to expand into new sites to the west of the city. Meeting the needs of communities. The scheme also plays an important role in supporting social inclusion and reducing inequalities. Mr. Kelly explained how the paucity of public transport access in the Cambourne to Cambridge corridor has an adverse impact on opportunities for those who do not own a vehicle through choice or personal circumstances, particularly younger people, but also those who are older. In this context, the reliability of journey times into Cambridge is essential, for example, for enabling school and sixth form students from Cambourne to take up work and work experience opportunities in Cambridge. The current unpredictable nature and duration of bus journeys prevents those opportunities from being realised and puts those based in Cambourne at a disadvantage to their counterparts living in Cambridge. Dr. Tracy accepted on behalf of the Coton Busway Action Group that these were current problems faced by school and sixth form students in Cambourne. They represent a clear inequality of opportunity for those living in or near to the Cambourne to Cambridge corridor, which will only increase as permissions in the area are built out. The scheme would also facilitate the provision of and access to more affordable housing for those working in Cambridge, again increasing the opportunities for those with more limited means to take advantage of the success and economic growth of Cambridge. While some objectors have objected to the scheme on the basis that they are opposed to growth generally in the Greater Cambridge area, Ms. Buckingham, on behalf of Friends of the Cam, did recognise that there was an issue with housing affordability in Cambridge and accepted that the enabling of further housing development in the Cambourne to Cambridge corridor would assist with resolving affordability issues. The case for Cambridge. The scheme is also important to facilitate the supercharged role for Cambridge envisaged by national government through the establishment of the Cambridge Growth Company, as recognised in the principle that the CGC must build upon and go further than the local plans in terms of scale, ambition and timescale. As Mr. Kelly explained, the emerging local plan is anticipated to be the platform for further growth facilitated by the CGC, who will also be responsible for unblocking stalled sites and ensuring certainty and confidence regarding housing delivery. The national ambitions for Cambridge amplify the need for early investment in and implementation of infrastructure such as the scheme, which will also provide greater certainty and confidence for investors. In Peter Freeman's words, there is no point aiming for growth unless you unblock infrastructure hurdles, and in doing so, you prove to the local community that their interests are also at heart. Furthermore, the unlocking of development at Cambourne West and Bourne Airfield by the scheme will be a springboard for further development in the Western Corridor, that in turn will be hardwired into the wider city ecosystem through the high-quality public transport connection made by the scheme. The scheme would also assist with connectivity for the Oxford-Cambridge arc, of which Cambourne to Cambridge forms the eastern end, and which has influenced ambitions for growth at Cambourne, Bourne Airfield, and the wider area west of Cambridge. The Emerging Greater Cambridge Local Plan. The latest version of the Emerging Greater Cambridge Local Plan was published on the 27th of October. This is a further Regulation 18 version of the Emerging Local Plan, which has been developed following updated housing and job forecasts and the resolution of concerns around water capacity through further evidence and the publication of a new water resources management plan. While it is currently undergoing a process of democratic approval by the councils prior to public consultation, Mr. Kelly confirmed that he does not anticipate any significant deviations or changes being made by members of the two councils, and certainly not in relation to the spatial strategy or ambitions for key settlements before the draft plan is consulted on over the winter. While the policies of the emerging plan necessarily carry limited weight due to their early stage of preparation, greater weight can be given to the direction of travel of the Cambridge spatial strategy towards growth in new settlements outside the city's historic core and surrounding greenbelt, and connected by high-quality public transport corridors. That direction was taken as long ago as the late 1990s and has been continually affirmed in the Council's development plans since then. Furthermore, following revised modelling regarding the required ratio of housing to support job forecasts, the housing numbers proposed for Cambridge are closely aligned with those which it would be expected to provide under the standard method, by contrast with previous plans where housing figures were higher than required under national policy in order to support increased ambitions for economic growth. The housing need provided for in the emerging plan can therefore be considered to reflect the up-to-date housing requirement for the Greater Cambridge area and should attract greater weight. The emerging plan also confirms the continued strong protection of the Cambridge Greenbelt in planning policy and the reliance on growth in settlements outside the Greenbelt, connected by public transport infrastructure through the Greenbelt in order to prevent Greenbelt release. As Mr. Kelly confirmed, the emerging plan does not provide for any release of Greenbelt for housing development. As capacity for new development on the edge of Cambridge has reduced, so new settlements have gained increasing significance for the supply of new housing, a trend which is carried forward into the emerging plan through the allocation of further strategic scale development at Cambourne North. Through its focus on new and expanding settlements, the emerging plan also continues that part of the spatial strategy which protects rural villages from sporadic piecemeal development. In response to concerns raised by CPPF and CPC and other objectors in relation to pressure for development in villages and in the Greenbelt as a result of the scheme passing through those areas, Mr. Kelly explained that having regard to the evidence base for the emerging local plan, there was no basis for the councils to pursue a spatial or planning strategy that would seek to deliver piecemeal development of those villages. Given the Council's own evidence regarding the significance of the Greenbelt in this location, it would make no sense to develop the Greenbelt solely in reliance on the infrastructure implemented by the scheme. Similarly, concerns regarding water scarcity have been taken into account in the emerging local plan and should not be considered as a matter pointing against the making of the order or the granting of deemed planning permission. Constraints on water capacity are well understood by the councils, and there is a process in place to mitigate potential risks arising from the levels of abstraction and water demand required to facilitate the development identified in the emerging plan. That process includes plans to transfer new supply from Grafham in 2032 and a new Fens reservoir from 2036 onwards, and the staircasing or phasing of development in line with those measures. As objectors accepted, any impact of water supply constraints on future development coming forward in the Cambourne to Cambridge corridor would be a matter to be considered through the planning application process for those developments. Furthermore, potential water supply constraints apply equally to any future growth in Greater Cambridge and are not specific to development which would be facilitated by the scheme. Ultimately, in response to questions from yourselves, Ms. Buckingham, on behalf of Friends of the Cam, conceded that water scarcity was not a reason to reject public transport improvements. The further version of the emerging plan continues to identify and rely on both the scheme and East West Rail to support the delivery of housing and employment growth in the Cambourne to Cambridge corridor, including a new allocation of 13,000 homes and 108,000 square metres of employment space at Cambourne North. Given the likely scale and significance of this further new settlement, Mr. Kelly explained that it is no longer appropriate to rely on a single piece of public transport infrastructure to connect Cambourne and Cambridge, particularly in the light of the differing routes that the scheme and East West Rail will take. The order and magnitude of the increase in development proposed at Cambourne will result in significant increases in pressure on trips to Cambridge. In that context, the scheme's importance for helping people to move sustainably between Cambourne and the city of Cambridge is increased. Mr. Kelly explained that the modelling underpinning emerging policies for Cambourne North that should be Cambourne, SCB Cambourne, not Cambridge, indicates that the scheme is essential for allowing the scale of development proposed in these allocations to come forward. Policies for Cambourne in the emerging plan also emphasise the placemaking role of the scheme in not just connecting Cambourne with Cambridge, but in enabling those living at Bourne Airfield and the surrounding villages to benefit from the increased scale of development at Cambourne, the proposed East West Rail station, and the corresponding benefits in terms of access to services and employment. The importance of the scheme to the emerging planning policy and site allocations for the Cambourne to Cambridge corridor is further emphasised in the busway integration report, which is part of the evidence base for the emerging plan. This report considers how the existing guided busway network could be extended to support the expanded Cambourne and Cambourne North proposals. It notes in particular that the proposed Cambourne to Cambridge busway will play a vital role in connecting both existing and future development to key destinations in Cambourne and Cambridge, including employment areas, education and healthcare, but that the full benefits of the busway will only be realised if it is fully integrated with the form and function of the evolving Cambourne settlement and with East West Rail. The scheme is described as a key enabler of development at Cambourne, having regard to current network constraints and the need to tightly integrate Cambourne's spatial and transport strategies to prioritise a mode shift away from car dependency. The scheme is envisaged as combining with East-West Rail services to provide a fast, reliable public transport corridor to Cambridge and key employment hubs. As explained by Mr. Kelly, this demonstrates the opportunities provided by the scheme to facilitate the delivery of sustainable growth being taken forward and capitalised on in emerging planning policy. The route options set out at pages 23 to 27 of the report also give an indication of the size of the potential future pool of residents, which runs into the tens of thousands, from which the scheme could draw passengers following the development of Cambourne North. The emphasis on the role of both East-West Rail and the scheme for development in the Cambourne to Cambridge corridor in both the emerging plan and the busway integration report should put to bed any remaining concerns that East-West Rail will make the scheme obsolete or that the two pieces of infrastructure are not complementary. As emphasised by Mr. Kelly, in order to effect behaviour change in terms of mode shift and the ability to satisfy travel needs through public transport, it is important that towns and settlements provide a range of public transport choices depending on the purpose or need for which a trip is undertaken. East-West Rail and the scheme are complementary in the sense that both pieces of infrastructure will, in different ways, enable people to live in Cambourne without needing a car. In any event, objectors' concerns regarding the impact of East-West Rail on the scheme and the allegation that East-West Rail would make the scheme obsolete appear to have largely fallen away. Mr. Whitton-Spriggs accepted on behalf of CBAG that factors such as cost, frequency, starting point and destination would influence whether Cambourne residents used the scheme or East-West Rail to travel to Cambridge, and ultimately conceded that the two pieces of infrastructure are complementary and that anything that gets private car traffic off the roads is advantageous. In re-examination, Mr. Lee confirmed that unlike the CPPF alternative, which he acknowledged was an interim solution, the scheme would be a permanent, albeit in his view incomplete, transport solution for Cambourne to West Cambridge, even once East-West Rail is in place. Mr. Littlewood similarly accepted that the need for a residual public transport scheme in the Cambourne to Cambridge corridor will remain even if East-West Rail is delivered. CPPF and CPC put forward no evidence to support the claim made in Mr. Littlewood's proof of evidence that the cumulative impacts of East-West Rail and the scheme would be unacceptable and unjustified to serve a relatively small population in the Cambourne area, even with significant future growth. Even if it was correct at the time of writing, which is disputed, this claim has been overtaken by the significant increase in housing proposed at Cambourne in the latest version of the emerging Greater Cambridge Local Plan. Compliance of the scheme with planning policy. As already explained, the councils, through their expert and locally informed officers, undertook a comprehensive review of the application and supporting material, including the environmental statement, and concluded that the submissions were appropriate to allow the councils to reach conclusions on the heritage and greenbelt balances and the overall planning balance. In the council's view, the overall compliance of the scheme with the adopted development plan and the limited nature of the residual planning harms justifies the order being made and deemed planning permission being granted, regardless of whether there may be a better or less harmful proposal which could be delivered instead. This is not the kind of exceptional case where the level of harm requires the alternative proposals put forward by CPPF to be taken into account as a matter of law as an obviously material consideration. Even if they are taken into account, they should be given little to no weight for the reasons given below and those provided in the applicant's oral and written evidence to the inquiry. The CPPF alternative. Mr. Kelly explained that the councils have not undertaken an independent assessment of the CPPF alternative or sought themselves to develop or suggest any alternative scheme. Instead, the councils have considered whether the applicant scheme achieves the objectives set out in the adopted and emerging local plans and the TSCSC of contributing to meaningful, substantial shift away from private car use through infrastructure enhancements delivered early in the development process for sites, and whether the scheme as a transport intervention can effectively deliver a paradigm shift in behaviour for all users. The councils consider that the process undertaken by the applicant for the consideration and development options over the past 10 years has been thorough and lawful and is sufficient to support the decision to promote the scheme. On the basis of the evidence provided by the applicant, the council's view is that the scheme does achieve the objectives required of it. As they do not present independent evidence on the matter, the councils therefore rely on and adopt the applicant's evidence on the CPPF alternative as presented to this inquiry, in particular in relation to reliability of service, the deliverability, feasibility and safety implications of the proposed changes to Madingley Road, the resultant harms to the SSSI and the heritage significance of the American Cemetery, and the further delay to the implementation of public transport improvements that would result from a refusal to make the order and grant deemed planning permission. As stated in opening, the scheme is critically important to enable the delivery of adopted development plan policy and the future expansion of Greater Cambridge in a sustainable and equitable way. The identified planning harms resulting from a scheme of this nature can be minimised appropriately through mitigation schemes and planning conditions, such that the resulting level of residual harm is low and is outweighed by the significant public benefits that the scheme will bring. You are therefore respectfully asked to recommend to the Secretary of State that the order be made, a direction be granted pursuant to Section 90 of the 1990 Act, and a certificate be issued pursuant to Section 19 of the 1981 Act. Thank you.
Thank you, Mr. Hopkin-Writer. Mr. Cameron, your turn for the applicant next. Can I just check with you how you intend to deal with written representations? Are those incorporated in your closings, or are you dealing with them separately?
Written representations we've been through, they're dealt with either in the statement of case or in the evidence already given. And that is how we're intending to deal with them.
Thank you.
And so I said I'd respond on the description of the busway in work number 1.
Yes.
And our position will be confirmed in the note which is to be submitted, but I'm instructed that it should read guided busway.
Right, in work number 1.
In work number 1. And indeed, sir, if you look at the note on the draft order that we put in, it refers to Article 37, and Article 37 applies in relation to guided busway.
Yes.
So it makes sense of that. So, sir, we do have a paper copy, which I can give you.
Thank you.
Thank you.
Thanks.
And so I understand, check, but I think that Ms. Vincent is about to put up an electronic copy on the website so others can access it. And so we are conscious of the time constraints, and because everybody who wishes can have access to the electronic copy, we will not read out every word. But we do rely on the entirety of the closing submissions.
Yes.
And although it may appear slightly long, the aim with this is to give you both a document which we hope will be helpful in preparing your report.
Thank you, Mr. Cameron. I just want to make sure that we're up on the... Yeah, Ms. Vincent's giving me the thumbs up. Mr. Parker, you can see it.
Tiny typo that might want to correct in the link, but yeah, the document itself is up there.
Right.
Well, I'm sure there'll be lots of typos in the document itself as well. Right, sir.
Okay, when you're ready, Mr. Cameron, then please.
And I'm going to read part of it, and Mr. Henderson is going to read other parts of it,
All right.
which will
Yes.
save you having to listen to me for too long. So we opened this case by noting the near universal agreement that there is a need to provide a reliable public transport service between Cambourne and Cambridge. That remains the position. Meeting that need is a pressing priority if the government's ambitions for growth at Cambridge are to be realised. There is little dispute that the proposed guided busway will meet that need, and it's now clear that there is no realistic and deliverable alternative means of meeting that need. So if the need is to be met, the national ambitions for Cambridge fulfilled, and the local plan and emerging plan strategy supported, the order must be made. Mr. Freeman, with all his extensive knowledge and experience, was plain. If a decision is taken not to proceed with the scheme which has been in contemplation for 11 years, it will undermine confidence in the government's ability to drive growth. A decision not to make the order would send a negative signal to the investors that this country so badly needs. It follows that in order to persuade the Secretary of State not to make the order, objectors would have to advance convincing arguments that harm caused or disadvantages associated with the scheme were so substantial as to justify taking a decision which would prevent that need being met, and that the alleged harm is so significant as to justify casting aside the imperatives set out in national and local policy. It is clear from the evidence that none of the objections advanced come anywhere near providing a reason to cast aside clear national and local policy objectives. In opening, we explain the status of the applicant and the applications which have been made, and we rely upon, but do not repeat, those submissions. We will adopt the matters on which the Secretary of State wishes to be informed as headings, and then we'll turn to the overall balance. We also ask you to note that agreement has been reached between the applicant and a number of parties with significant interests, including those with regulatory functions. The Environment Agency withdrew their objection. Historic England do not object. An agreement has been made between the applicant and National Highways in relation to the M11 overbridge. National Highways have reiterated that they are supportive of the scheme and agree that the state of negotiations is as set out in Mr. Franklin's schedule. It is proposed that 2 plots are to be removed from the order. National Highways' supportive position is of particular importance given that exercise of certain powers is dependent on their consent. And the following objections have been withdrawn. National Trust, Clare Hall, Bedlam Farming Company and Chivers Farms Limited, Cambridge University Rugby Union, Cadent Gas, East West Rail. At the time that Mr. Franklin gave evidence, the position in relation to statutory objectors is set out in the core document, and Cadent Gas's withdrawal occurred after that schedule was produced. So we turn to matter 1, aims, objectives and need. And the scheme objectives are worthy of being set out in full, which we do, but I don't read it out. There's been little or no challenge to the scheme aims and objectives or to the identified key drivers for the need for change. They may not be shared by all, but the vast majority of those participating in the inquiry see it as desirable that those aims and objectives be advanced. And in order to deliver those objectives, it is necessary to deliver a reliable public transport service between Cambourne and Cambridge. Greater Cambridge has a vital role to play in the government's mission to kickstart economic growth. The local plan strategy received express endorsement in the case for Cambridge, and in his letter appointing Peter Freeman as chair of the Cambridge Growth Company, Matthew Pennycook MP set out the government's priorities. Those priorities include developing an evidence base to support development of an infrastructure-first growth plan. And the current government's emphasis on growth in Greater Cambridge also places emphasis on building on and going further than local plans. The government's support for the local plan strategy could not be clearer. A central element of the adopted local plan strategy is to promote strategic scale development at Cambourne. 2 out of the 3 strategic scale developments identified in the policy are at Cambourne, a new village at Bourne Airfield and Cambourne West. The new village at Bourne Airfield is dependent on significant improvements in public transport provision, including provision of high-quality bus priority measures or a busway on the C2C route. That dependency is demonstrated by the imposition of Condition 13 on the Bourne Airfield planning permission, which provides that no more than 500 of the 3,500 dwellings shall be occupied until the C2C scheme, I should add, or equivalent, is operational. As Mr. Kelly explained, given the early investment required to bring forward a development of this scale, investors and funders are unlikely to incur expenditure until it's known that the full 3,500 units can be delivered. and Mr. Sensical took a similar view. Mr. Kelly also explained the background to the imposition of Condition 13. The members decided to delete what he described as the facility to agree a variation, as had been suggested by officers. It's clear from the policy framework and the specific terms of the planning permission that the order scheme is required to unlock the major development anticipated at Bourne Airfield. Contrary views, such as that put by the Mayor when he said in oral evidence that such conditions can be changed by agreement, are unrealistic and incorrect. And it now appears from the Mayor's closing submissions that it was based on a mistaken understanding that the restriction was in the Section 106 agreement. A similar policy approach is taken in relation to Cambourne West. The policy provides that the development will need to address the provision of high-quality segregated bus priority measures on the A1303 corridor. Mr. Kelly explained that when planning permission was granted for the Cambourne West scheme, the view was taken that the busway scheme could be secured by requiring the developer to make phased financial contributions. The decision was taken in the light of the city deal arrangements which secured funding for the busway. At the same time as promoting a significant scale of development at Cambourne, West Cambridge is promoted as an academic and employment centre of significant scale. That's policy 19 in the Cambridge local plan. As noted in the recent justification, key to the success of the proposals is an integrated and sustainable transport strategy which includes public transport. The outline planning permission which has been granted is a model of the type of development which makes Cambridge a focus of the government's growth ambitions. It combines academic and research floor space with commercial areas, and we set out the floor space. This is the very type of development which will facilitate the in-person interactions which lie at the heart of the Cambridge phenomenon. Realising this development at this scale is dependent upon the public transport service which the order scheme will provide. The emerging local plan goes further. It is designed to meet the need for 73,300 additional jobs to support knowledge-intensive employment and a minimum of 48,195 new homes over the plan period, which goes to 2045. Whilst also looking beyond that period. Among the factors which influence the plan strategy are the constraints imposed by Greenbelt and the opportunities offered by existing and committed public transport schemes, including the order scheme. The spatial strategy which has been devised to meet that need, whilst respecting the constraints and taking advantage of schemes such as C2C, is well illustrated by figure 75. As Mr. Kelly explained, the opportunity to expand Cambridge further without harm to Greenbelt purposes is almost exhausted. As a result, it is necessary to look beyond the Greenbelt. The emerging local plan strategy reflects that position as it promotes strategic sites beyond the Greenbelt, such as at an expanded Cambourne. The strategy depends upon the delivery of transport infrastructure early in the process. The order scheme is an essential part of that infrastructure. So delivery of many key policies in the emerging local plan are dependent on the order scheme, and we set those out. Mr. Kelly's conclusions are based upon the detailed work that has been undertaken to support the emerging local plan. That work includes the bus integration report, which states that due to current network constraints, development at Cambourne will be subject to a vehicular trip budget. The provision of C2C is essential in order to allow the anticipated level of development to take place whilst not exceeding the vehicular trip budget. The views of Mr. Kelly should be given particular weight. He spoke as the Joint Director of Planning for the Greater Cambridge Shared Planning Service on behalf of South Cambridgeshire District Council and Cambridge City Council, the head of the service responsible for the local plans. He said there is absolute alignment between the order scheme and the local plan strategy. There can be absolutely no doubt that the C2C scheme is required in order to deliver the existing and emerging local plan strategy. The need to provide the scheme is abundantly clear. Indeed, there are few applications which benefit from such strong policy support. In addition to the strong policy support and the need based upon providing a public transport scheme to facilitate and support the local plan strategy, the scheme will also meet a need to address delays and unreliability which affect traffic movements and the current bus services. The transport network is unable to accommodate vehicle movements based on the 2041 Do Minimum Baseline Transport conditions. Volume to capacity figures for junctions in the study area demonstrate volume to capacity of greater than 100% at 24 locations in the AM peak, 6 locations in the interpeak period, and 28 locations in the PM peak. On Madingley Road, between the Madingley March roundabout and the M11 junction, the model predicts eastbound congestion in the AM peak and east and westbound congestion in the PM peak. Whether one takes the model outputs based upon the F-Series model or Mr. Lee's inbound journey time information for 2024, it can be seen that there is a significant variation in bus journey times on the A1303. That variation and the consequent unreliability of the service demonstrates the transport need for the scheme. As a result, most objectors do not seek to argue that there is no need for enhanced public transport provision. They accept there is a need. The position is best demonstrated by considering the position of CPPF, Coton Parish Council. CPPF agree with the scheme objectives, as we've already set out. Mr. Johnston accepted that an intervention is necessary in order to address bus delays between Cambourne and Cambridge, whether based on the 2019 figures or CPPF's 2024 figures. He said that there was a policy requirement for such a scheme. Mr. Johnston also accepted that the applicant scheme would meet the need, whilst arguing that the CPPF alternative is to be preferred. Mr. Lee agrees that there is a need in principle for a reliable public transport service between Cambourne and Cambridge, and that an intervention is required in order to meet that need and achieve the scheme aims and objectives. Mr. Littlewood says that there is a compelling need to improve public transport between Cambourne and Cambridge, and Mr. Littlewood went on to agree that the applicant scheme will meet that need. He also said that the CPPF did not seek to challenge the strategy set out in the adopted local plan. Other objectors took the same view. As examples, Mayor Paul Bristow supports growth at Bourne Airfield and Cambourne and said that in order to facilitate that growth, there is a need for a transport scheme in the form of the C2C scheme or equivalent. Mr. Davidson accepts the principle of a Cambourne to Cambridge busway and that it is needed to serve the Cambridge West development. The Coton Busway Action Group supports the initiative to provide better transport links between developments west of Cambridge and employment and education opportunities in and around the city. The Federation of Cambridge Residents Associations considers that improving public transport, including from Cambourne to Cambridge, should be a priority. Dr. Green said that a busway to West Cambridge is desirable. Mr. Lee suggested that as the worst congestion is experienced in the AM peak, there's no requirement for a two-way busway. Such a suggestion is inconsistent with the acceptance of a need for a reliable public transport service between Cambourne and Cambridge. A bidirectional segregated busway eliminates the possibility of interferences from other road users and thereby provides the greatest reliability. If, as agreed, the need is for a reliable public transport system, that need would not be met by a one-way only route. Even Mr. Lee, in his report, recognises the difficulties with a one-way route and contemplates that further interventions may be necessary westbound at Madingley Mulch. For those reasons, it's clear. First, that it's widely accepted that there is a need to provide reliable public transport between Cambourne and Cambridge. Second, without a scheme to provide such a public transport, the government's aims for growth at Cambridge will be thwarted and the local plan and emerging local plan strategy will fail. Third, the scheme objectives are wholly desirable. The scheme will meet the identified and acknowledged need and will support the local plan and emerging local plan strategy. Fourth, in the absence of a deliverable and preferable alternative, the order must be made so that the need can be met and the policy objectives achieved. Matter 2 is statutory procedural requirements. We rely on this section, but I'm not going to read it out because it's not a matter that has been ventilated in any detail at the inquiry. So I go on to matter 3 on page 14, main alternatives considered. Consideration of alternatives is an important issue in this case. Most objectors accept there is a need to provide improved and reliable public transport between Cambourne and Cambridge. Most objectors also accept that the applicant's scheme would meet that need. As a result, a very large number of objectors object to the applicant's scheme on the ground that there is a deliverable alternative which will achieve the scheme aims and objectives whilst causing a lesser degree of environmental harm. If there is no such deliverable alternative, most of the objectors' cases fall away. In addition, the arguments against taking a busway across agricultural land and a county wildlife site in the Greenbelt are also much diminished. Indeed, if there is a compelling need and no alternative means of meeting that need, the benefits of the applicant's proposal become overwhelming and outweigh the harm that will result, whether to Greenbelt, agricultural land, traditional or other orchard, or otherwise. Given that context, the Secretary of State's consideration of alternatives is likely to play a central role in the decision-making process. In order to seek to assist the Secretary of State in that process, in making recommendations to her, we will address the issue of alternatives by addressing the following issues. We'll identify the applicable legal framework. Then we'll then go to the rationale for the preferred option and the alternatives considered, then the costs of the scheme and overall benefits, and then the alternatives supported by objectors. So the first heading there is legal framework. I'm not going to read that out, so I'm going to go to page 17, the rationale for the preferred option and the alternatives considered by the applicant in this case. The requirements of Rule 11.1d are met in the environmental statement, in particular at Chapter 4 of the main volume and in Addenda 1 and 2. In his evidence, Mr. Baker sets out the history of option selection and consultation. There was no substantive challenge to that element of his evidence. As Mr. Baker explained, the analysis was detailed and extensive, including multiple rounds of consultation. The output of that assessment was the route for the busway as it is presented at the inquiry. Although some objectors had suggested they would seek to argue that the applicant's consideration of alternatives had been deficient, in that an on-road alternative had not been assessed, that point has not been pursued with any vigour at the inquiry. It's easy to see why the argument was not pursued with vigour, as it is clear that on-road options have been considered, as accepted by many, including Mr. Lee. As an example, the 2017-2018 consultation include two on-road options, routes A and B, Route A was for an inbound near-side bus lane, and Route B was for a central tidal bus lane. It's clear from the extensive documents that the applicant considered much more than the principle of an on-road route. They considered principle and detail. The Mott MacDonald report is an example of how the detail was considered. It's clear that the applicant has undertaken a clear, transparent and comprehensive consideration of alternatives, and the options considered included on-road solutions on the existing A1303. The scheme has been promoted at this inquiry is the product of that extensive process. So we then turn to the cost of the scheme and overall benefits. First, the funding statement. In accordance with the rules, a funding statement has been submitted. The anticipated cost of the scheme is approximately £192 million. The scheme is to be funded by City Deal monies together with contributions from dependent developments, including Cambourne West, Bourne Airfield and West Cambridge, as confirmed by Mr. Baker. No objector has presented detailed evidence to the inquiry that the scheme will not be funded. Ms. Gaisley sought to cast some doubt on funding, but did not question the fact that the GCP has been allocated funding under the City Deal. There can be no serious doubt that funding is available, and it's clear that should the order be made, there are sufficient funds available to deliver the scheme. Turn to the business case. Much time has been spent at the inquiry discussing the economic case, which forms part of the business case. The discussion of this topic must be seen in context. As agreed by Mr. Lee, the business case process provides the basis for investment decisions, not decisions on whether to make a Transport and Works Act order. The economic case is one element of the business case. The value for money framework itself is not limited to monetized benefit cost ratios. It requires a holistic approach. The business case analysis is not a substitute for the overall planning balance. A monetary value is not placed on every element of the scheme. Given that context, and given that the scheme meets the important strategic objectives of contributing to the growth of Cambridge in line with the extant and emerging local plan strategy, it is not necessary to resolve all the detailed points made about assumptions made in the economic case. Given that context and the role that the economic case plays, we are not going to spend a large amount of time assessing each of the points taken in great detail. The big picture points are that funding is secured, the balance of benefits and harms cannot be fully captured in a BCR metric, and it's clear for the reasons we give later in these submissions that the benefits far outweigh any harm. When attention is turned to the economic case and the value for money assessments, it's also important to bear in mind the May 2025 value for money framework, which identifies 3 BCR metrics: initial, adjusted, and indicative. The indicative impacts are the last stage of the assessment. Indicative impacts are of particular importance in this case, given the central role that the scheme will play in facilitating development at Cambourne. The indicative BCR for this project at 1.8 to 1 indicates that the scheme is medium value for money. Objectors have sought to attack the analysis undertaken by WSP on behalf of the applicant on a number of different grounds. The main grounds of attack are use of a pre-COVID transport model, Cambridge Sub-Regional Model Series F, account taken of East West Rail, and the assumptions made as to development dependency. So a turn to the transport model. CPPF argue that a new sub-regional transport model should have been developed to take account of post-COVID pandemic travel conditions. It's to be noted that this point was taken by CPPF on the basis of Mr. Johnston's evidence that a normal or steady state has now been reached. CPPF called no substantive evidence in relation to the Cambridge sub-region to support that contention. In fact, the most up-to-date recovery tracker figures suggest that the bus passenger numbers have not returned to a steady state. There was a 31% increase in the existing guided bus passenger numbers from 2024 to 2025. The applicant was alert to the need to consider changes following COVID lockdowns. The approach taken was to test the materiality of the uncertainties arising from post-COVID pandemic travel conditions, applying the guidance in Tag Unit M4. The issue to be determined is not whether different approaches could have been taken, but whether the approach taken by the applicant fell within a reasonable range of options. Tag Unit M4 states that ideally, analysts should consider rebasing their model in response to events such as the COVID pandemic, but that since rebasing can come at considerable cost and takes time, more proportionate approaches can be considered. Guidance on proportionate accounting for COVID-19 is set out in Appendix B3. The applicant selected one of the permissible options. Others may take a different view, but so long as the decision fell within the ambit of what was reasonable, it cannot and should not be criticised. The essence of a proportionate response in these circumstances is to avoid excessive reworking of models and will often be based upon applying broad sensitivity tests. The applicant considered that applying a post-model adjustment was the appropriate response. The COVID sensitivity test gave a lower value for conventional transport benefits, but made no material difference to the overall value for money. The sensitivity test produced an indicative PCR of 1.7 to 1. CPPF's focus on the travel benefits to the exclusions of others, for example, in their closing submissions, is unduly narrow. CPPF sought to rely on the introduction to the F-Series model forecasting report. The introduction notes that the F-Series improved the level of detail in areas that are the focus of current transport scheme projects and added a 2019 current year validation to extend the life of the model until such time as a whole new base year can be created once the disruption attributable to COVID-19 has settled to a new normal state. The forecasting report does not specify a particular date when a new base year is to be created. Mr. Johnston accepted that Tag Unit M4 was relevant, but then sought to argue that it was not appropriate to follow the approach set out in that Tag Unit when a proposal includes powers of compulsory purchase. Mr. Johnston's approach is misconceived. The purpose of the business case is to inform public sector investment decisions, and although the business case can be relevant, the decision on whether or not to authorise compulsory acquisition of land is based on much wider considerations. So the applicant's approach followed the relevant guidance in the Tag Unit and applied a post-model adjustment. Given the part played by transport benefits in the overall economic case outputs, that approach was proportionate and reasonable, and we invite you to so find. Turn to East West Rail. The issue in dispute is whether the effects of East West Rail should have been modelled in detail in the business case. The applicant's position is that in accordance with the relevant TAG guidance, it was not appropriate to model EWR as part of the core scenario. That point was agreed by Mr. Lee. The reason for not including EWR in the core scenario is quite simple. The scheme still has some way to go in the consenting process. The table in the TAG unit provides guidance on when future input should be included in the core scenario. EWR has not been consented. Indeed, no application has yet been made for a development consent order for the relevant part of the route. It does not fall into the category of a scheme which should be part of the core scenario. The TAG unit also notes that it's important that analysis of alternative scenarios is proportionate. CPPF assert that EWR should have been part of an alternative scenario. However, Table A2 is clear. Reasonably foreseeable or hypothetical inputs may form part of the alternative scenario, but whether they do or not remains a matter of proportionality and judgment. The applicant's judgment that modelling an alternative scenario to account for EWR was not proportionate cannot be faulted. Our submissions and the application of the tag unit are not affected by the fact that the planning authorities modelled the effect of EWR for the purposes of local plan preparation. The planning authority modelled EWR as an additional scenario, not as part of the baseline or core, which was a matter for their judgment in different circumstances for a different output. In any event, as Mr. Whitehouse explained, the order scheme and EWR are anticipated to complement each other. One scheme goes to West Cambridge and to the city centre, and the other to Cambridge South and Central railway stations. If that point was not clear from the existing planning framework, it is abundantly clear from the emerging plan and its evidence base. The bus integration report makes plain that both EWR and C2C are required to support and facilitate sustainable growth. If that was not sufficient, further support for the view that EWR and C2C are complementary is provided by the fact that EWR Limited have withdrawn their objection, and in so doing, state that the C2C project will enhance public transport and facilitate sustainable development, being outcomes which are very much aligned with the objectives of EWR. As with the criticisms of the approach taken to the version of the transport model used, this point does not advance the case made by the objectors. The majority of the economic benefits that flow from the scheme are derived from land value uplift. If there are changes to transport patterns as a result of other transport schemes, such as EWR, there will be no impact on land value uplift and no material impact on the value for money category, as demonstrated by the sensitivity analysis. Now turn to the third point, development dependency. The first point raised is whether certain development, in particular housing at Cambourne West, should have been included as dependent development, and the relevant tag unit gives guidance on this issue. Paragraph 322 indicates that the issue of whether a development is dependent is not usually clear-cut. A dependency is likely to occur where a development will breach a reasonable level of service on the transport network. Decisions regarding dependency are ultimately judgment-based. In making the judgments, the correct criterion was applied, and that's the reasonable level of service point. And in the footnote, we refer to the relevant part of the CPPF closing. Further, in making the judgment for the purposes of the business case, account was taken of the basis upon which planning permission was granted, namely that the developer was required to enter into a planning obligation to make a financial contribution towards the cost of funding improvements to highway infrastructure so as to improve links by bus from Cambourne to Cambridge. Such a planning obligation could only have been sought if it was necessary to make the development acceptable in planning terms. If a contribution is necessary in order to make a development acceptable, that development must be dependent upon the infrastructure to be funded. To put it another way, and based on Mr. Kelly's words, the payment was necessary to mitigate the impacts of the development proposal that the C2C scheme unlocked. The clear conclusions to reach under the first point are that in carrying out the business case assessment, the applicant applied the correct test. Cambourne West, like Bourne Airfield, is a development that is dependent upon the provision of the order scheme or equivalent. The second point raised relates to the values adopted when making the assessment, and particular house price values and house price growth assumptions. In order to arrive at house price value assumptions, the business case relied upon an expert surveyor's report prepared as part of the local plan evidence base. In contrast, Mr. Lee took figures which were not based upon the type of houses likely to come forward in the relevant developments and took no account of new build premium. There can be little doubt that the applicant's figures are to be preferred. Although the analysis took up a lot of inquiry time, one may wonder what the purpose of raising these points was, as Mr. Lee accepts the figures set by Mr. Whitehouse in the document Response to Alternative Scenarios for Land Value Uplift Assessment. So, with Bourne Airfield only, i.e. with Cambourne West excluded, which it should not be, the BCR is 1.5. Even if you adjust house prices down, the BCR is 1.3. With lower house price growth, the BCR is 1.3. And in order for the BCR to fall below 1, it's necessary to make multiple inappropriate assumptions, namely Bourne Airfield only plus house prices adjusted plus nil future growth. If one adopts a nil future growth sensitivity test, one should also consider the other end of the range. That's 5% house price growth, and that produces a BCR of 3.2. At paragraph 42 of his closing, Mr. Parker was keen to refer to the MHCLG appraisal guide advice on testing low sensitivities, but omitted to refer to the other end of the range. If it's right to look at the low end of the range, it must be right to also look at the other end of the range. Any reasonable submission would not have ignored that point. Those sensitivity tests demonstrate how robust the analysis is. In order to depart from median value for money, that's the indicative BCR 1.8 to 1, unrealistic assumptions would have to be made. And there's no good reason to reject the analysis set out in the business case. Now turn on to alternatives advanced by objectors. Objectors seek to argue that harm to the greenbelt, to the countryside and to nature conservation would not be justified if there was a realistic and deliverable alternative which did not cause such harm or which caused a lesser degree of harm. To be a true alternative, a proposal must meet the scheme aims and objectives. If those aims and objectives are not met, the scheme put forward cannot be considered to be a true alternative. Furthermore, any alternative must be realistic and deliverable. As Mr. Johnston agreed, a scheme to alter an existing highway will only be deliverable if it's acceptable to the Highway Authority. In determining acceptability, the Highway Authority will apply its published policy. In this case, the published policy is set out in the Cambridgeshire County Council document. Mr. Johnston accepted that the guidance should be the starting point for any scheme design. He also accepted that the relevant part of the A1303 is a strategic link to which the guidance in paragraph 2.31 of the County Council General Principles document applies, and therefore Design Manual for Roads and Bridges applies. It's clear that the standards against which any on-road proposals on the A1303 are to be judged are those set out in DMRB. We now turn to the CPPF alternative. The objectors have coalesced around the CPPF alternative, and I use that term to cover CPPF and Coton Parish Council's alternative. We will go on to consider the detail, but the short answer to the CPP alternative is as follows. By making an assumption that the scheme should be confined within the constraints set by the, this is Mr. Johnston's term, the environmentalist, CPPF acknowledge and accept that a scheme which did not fit within those constraints would have unacceptable environmental consequences. It's abundantly clear that a scheme which meets the relevant safety and other standards cannot be accommodated within those constraints. As a result, it's clear that an on-road alternative of the type promoted by CPPF cannot be delivered. To be safe, an on-road scheme has to breach CPPF's environmental constraints. As a result, Mr. Woodfield's assessment of the environmental effects of the CPPF alternative are of little assistance. It is a product of the constraints he set. A scheme falling within the constraints set by him cannot be delivered. To the extent that it may be suggested that some alternative could be developed, not bound by those constraints, such a scheme has not been developed, it is not before the inquiry, and falls into the vague or inchoate category. And that I didn't read out the part on legal framework considering alternatives, but you'll see those words when you go back to that part. I turn to evolution of the scheme. CPPF commissioned Mr. Lee to devise an alternative on-road scheme. Mr. Lee's work started with the February 2021 report, which was placed before those carrying out the audit. At that stage, the on-road solution was put forward as an interim solution to buy time, Mr. Lee's words, while the details of longer-term infrastructure were worked out. The longer-term infrastructure referred to in 2021 included CAM, Cambridge Autonomous Metro. In February 2021, the CAM proposals included a route between Cambourne and Cambridge. The report of the auditor noted that the fact that an in-highway scheme may provide an interim solution did not invalidate the assumptions and constraints for the preferred option as a long-term solution to meet the growth in travel demand along the corridor. It's important to note that a scheme which was initially promoted as an interim solution is now promoted by CPPF as a longer-term solution. That gives an immediate indication of how unsuitable the CPPF proposal is. It's also important to note the point made by the auditor that the applicant's preferred option, now the order scheme, is promoted as a longer-term solution to meet the growth in travel demand. Mr. Lee's proposed solution, even if deliverable, would not meet that demand. In September 2024, after various iterations, Mr. Lee proposed an inbound central bus lane. It's not surprising that the central bus lane solution is no longer promoted by CPPF. It's unsafe for all the reasons explained by WSP, and CPPF's own witness, Mr. Johnston, agrees that it is unsafe. In April 2025, a further version of the CPPF scheme was put forward. In devising that scheme, Mr. Lee relied upon lane widths taken from an active Travel England document. That guidance does not apply to roads such as Madingley Road, and Mr. Johnston did not recommend its use. The WSP report commissioned by the applicant was available in July 2025. That report was not limited to criticisms of Mr. Lee's scheme. It included an alternative concept design. The approach taken in preparing this report demonstrates once again that the applicant has examined suggestions made by objectors with care. Such suggestions have not been dismissed out of hand. The applicant has gone further and has investigated whether, with changes, suggestions made by objectors might be able to be delivered. It is quite wrong to say that the applicant has devoted little energy to examining how constraints can be overcome, as Mr. Parker submitted. To the contrary, every effort has been made to see whether difficulties can be overcome. Despite that effort, WSP concluded that an on-road inbound bus lane option could not be delivered. CPPF's final scheme is that set out in the August 2025 report appended to Mr. Lee's proof of evidence. The history we've set out is not merely a passing interest. It shows that CPPF have persisted in promoting what was devised as an interim solution to buy time as a longer-term solution, and that despite the various iterations, it is a scheme which does not comply with the relevant standards. So we turn to the August 2025 scheme. Mr. Johnston explained how the August 2025 scheme was devised. The constraints were set by the environmentalist, Mr. Woodfield, and civilistics were instructed to design a scheme which abided by those constraints. The scheme was not designed to meet standards. The standards were only considered once the constraints had been set. As a consequence, the resulting lane widths are too narrow, and important features, such as an appropriate hard standing between the bus lane and the active travel path, are omitted. In arriving at their design, CPPF did not produce their own cross-sections. The CPPF scheme is based upon two-dimensional drawings which do not take account of levels, crossfall, etc. The only cross-sections available are those produced by Mr. Lonergan. Based upon the civilistics drawings and his cross-sections, Mr. Lonergan has identified multiple departures. When the CPPF scheme is tested against the standards set by the Highway Authority, Mr. Lonergan identifies significant departures or failures to meet the appropriate standards. Mr. Johnson said he had no reason to doubt that analysis. One way in which CPPF seek to overcome those departures is by arguing that a lower speed can be specified. That approach is not likely to be acceptable given the characteristics of the road, and even if implemented, major departures would remain, and amongst those departures are non-provision of 1 metre hard strips, substandard lane widths, and the reduction is 3.65, not 3.6, to 3.25, substandard verge widths, substandard footway widths, inadequate stopping sight distances. In addition, Mr. Johnson says that the level of the road would have to be lowered, in particular in the vicinity of Madingley Wood. That issue is not being considered by CPPF in any detail. Even a scheme based upon CPPF's unrealistic assumptions and with the multiple departures identified will have an adverse impact on the significance of the American Military Cemetery, Registered Park and Garden. That much is accepted by Mr. Littlewood when he says that the CPPF proposal will cause less than substantial harm to the significance of the designated heritage asset. Mr. Littlewood assessed the level of harm as low, and in his oral evidence he changed his position from that stated in his proof. Mr. Littlewood's analysis is based upon the assumption that the scheme does not require any land covered by the RPG designation. That is an inappropriate assumption even based on the CPPF position. The RPG extends to the road and includes the grass semicircular area at the entrance. Even on the CPPF's unrealistic assumptions, part of the grassed area will be lost. As far as can be gleaned from the map, that area is part of the land given to the United States government and which is subject to the agreement made between the British and American governments, being an international treaty. That point stands whether or not that land is considered to form part of the highway. And even if the area taken were found not to be part of the RPG, it's plain that it forms an important part of its setting. It is at the entrance to the cemetery to which the eye is drawn. If account is taken of the need to provide adequate lane widths, hard strips, and so on, and of the extent of the land required to build up verges, it's clear that it's not possible to add a bus lane to the existing carriageway without intruding on the land covered by the treaty, either the pink land or the yellow land, and without causing a material degree of harm to the registered park and garden itself and its setting, and to the setting of the listed memorial and attached walls, steps, and pool surround. Mr. Littlewood's suggestion that the heritage value of the listed memorial and attached walls, steps, and pool surround is on the north side of the wall demonstrates how little understanding of heritage significance he has. The fact that the wall acts as a boundary does not prevent development outside the boundary from affecting significance through development within the setting. Furthermore, in this case, the CPPF alternative will pass by the opening in the built structures at the point where the listed building opens up to invite the public in, the entrance. Furthermore, the solution for the M11 overbridge set out in the civilistics drawings is not supported by CPPF's own witness. Mr. Johnson said he would not deliver a scheme on the basis set out in cross-section HH, that in his view such a scheme was undeliverable. Mr. Johnston went further than that. He said that such a scheme would be unsafe. In coming to that judgment, he agrees with Atkins in their report. They said that such a design would lead to a higher risk of accidents and greater congestion. As Mr. Johnson said, everyone with the requisite expertise who has considered the CPPF proposals for the M11 overbridge considers them to be unsafe. Mr. Johnston's suggested solution is to provide an additional bridge. However, such a bridge does not form part of the CPPF scheme. Furthermore, the impact of such a bridge and the feasibility of its construction has not been assessed. The approaches have not been considered. The extent of land required to be acquired and any environmental impact have not been assessed. In their closing submission, CPPF entirely ignore the evidence of Mr. Johnson that their own scheme was unsafe. They seek to gloss over their inability to traverse the M11 safely and rely now on two bad points. The first is Mr. Lee's completely unsubstantiated assertion that adjustments to signals and off-slip would resolve the point. This has no evidential basis and is the epitome of a vague or inchoate scheme. The second is the Atkins report. However, as already explained, rather than supporting CPPF's position, the Atkins report actually corroborates Mr. Johnson's view on the absence of a safe option which does not involve an entirely new bridge or very extensive widening of the existing bridge. These cannot now be plucked out of context by CPPF. Any fair reading of the Atkins report reveals the preliminary nature of the work and the many unresolved issues which it identified, not least the absence of any agreement or meaningful discussions with National Highways. Even on CPPF's own evidence, their scheme is incapable of being developed. That is sufficient to conclude that the CPPF alternative is not realistic or deliverable. In addition, on the evidence, you have no evidence on the cost of the CPPF scheme. The figure of 37.7 million at page 7 of Mr. Lee's Appendix A comes from the business case, low cost option B. Low cost option B relates to part of the route, that part east of the Madingley Mulch roundabout, together with the Scotland Farm Park and Ride. The 37.7 million figure omits works west of the Madingley Mulch roundabout. The cost of a new bridge over the M11, as described by Mr. Johnston, has not been assessed, and the figure included in Mr. Lee's appendix cannot and should not be relied upon. You cannot assess the extent of the harm to the Madingley Wood SSI and the American Military Cemetery, as a scheme which complies with applicable standards with appropriate lane widths has not been assessed. The construction effects of creating a new road by reducing levels, as recommended by Mr. Johnston, have not been assessed. You cannot be sure how or whether the M11 overbridge issue can be addressed. For all those reasons, contrary to the submissions made by Mr. Parker in closing, on the evidence, the CPPF alternative will not meet the objectives of the scheme, is plainly not feasible in engineering terms, is on their own evidence unsafe, lacks robust assessment of ecological impacts for the true nature of the works that would be needed, both to deliver Mr. Johnston's new bridge over the M11 and to lower the entirety of the road, would, as is now accepted on their own evidence, cause harm to the significance of the designated heritage assets at the American Military Cemetery, cannot deliver compliance with the development plan as it's clearly undeliverable, has an unknown cost, and will inevitably take longer to deliver than the applicant's busway by at least 5 years. The fact that some moderate greenbelt harm might be avoided or lessened is of very little relevance, given the fact the scheme is unsafe and undeliverable. CPPF sought to argue that the acknowledged need for an active travel route between Cambourne and Cambridge could be met by relying on the Cambourne Greenway proposals. However, those proposals do not include a route from Cambourne to Cambridge. The proposed route does not even go to Hardwick. So the only rational conclusion to come to is that the CPPF scheme as promoted is not capable of being delivered. A hypothetical scenario was put to Mr. Sensical in cross-examination. The assumptions which Mr. Sensical was asked to make were that the CPPF scheme was deliverable within a similar timescale, the CPPF scheme was feasible and safe, the CPPF scheme would deliver equivalent transport benefits. That hypothetical scenario is so unrealistic as to make any assessment based upon it utterly meaningless. An alternative scheme, whether proposed by CPPF or some other alternative, could only begin to be considered once a decision has been made on this application. If post-decision on the order application, a decision were to be taken that an alternative scheme is to be advanced, a consultation process would follow. Once the consultation process was complete, a decision on a preferred route and scheme would have to be taken. Requisite consents would have to be obtained, including from National Highways. At the absolute minimum, a compulsory purchase process would have to be followed in order to provide a new bridge over the M11. And it is wholly implausible to suggest that the CPPF alternative could be delivered within a similar timescale to the order scheme. Secondly, for the reasons given by Mr. Lonergan, the CPPF scheme is neither feasible nor safe. And thirdly, the transport benefits of an on-road scheme were considered as part of the option appraisal process, and an on-road scheme does not provide equivalent transport benefits. In the alternative, if you rejected the submission that the CPPF alternative is incapable of being delivered, you cannot be satisfied that the CPPF scheme, put forward as an interim solution, even if capable of being delivered, would meet the travel demands associated with the long-term growth aspirations. Those growth aspirations are based upon placing a cap on vehicular trips, the trip budget approach, which relies upon the delivery of the C2C scheme. You can be certain that the CPPF alternative would not provide the long-term infrastructure which Mr. Kelly told you is required to deliver the paradigm shift in travel behaviour. So even if, contrary to our submissions, you find that the CPPF scheme is deliverable, it's not a true alternative, as it will not meet the need. We now turn to some more detailed points. Next, realignment of the off-road busway at or near Coton. Mr. Littlewood for CPPF put forward an argument that the busway should follow a curved alignment west of Cambridge Road. That suggestion has not been supported by any detailed analysis to either establish that it is feasible or that it would in fact improve farming viability. It falls into the vague or inchoate category. Some objectors have suggested that the busway should have been realigned to avoid the original Bramley apple trees. A realignment of the route is considered in the first addendum to the environmental statement, and we consider that option later in these submissions when considering impact on Coton Orchard. But the assessment demonstrates that the alternative would result in wider environmental impacts as well as being inferior on operational and safety grounds. In addition, this alternative is not supported by the landowners. It follows that this alternative cannot be given any weight if it is even a relevant consideration at all. We then turn to rifle range track. Some, such as the Goffway Residents Association, have suggested that a route along Adams Road is to be preferred over the proposed section of route along the rifle range track. Both the rifle range track and the Adams Road options were fully appraised through the preparation of the option appraisal reports between 2018 and 2019, with further consideration before the outline business case was reported to the GCP's Executive Board in 2021. As the second ES addendum demonstrates, the output of the appraisals in the option appraisal report is that the rifle range track is the better option once the now abandoned Cambridge Autonomous Metro is discounted. It follows that the Adams Road option does not provide a proper basis for objecting to the busway as now proposed. Further, even if contrary to the applicant's case, Adams Road were considered to be a potentially preferable option, when making a judgment, account would have to be taken of all relevant factors, including delay. Once these factors are taken into account, it's clear that Adams Road cannot properly be considered to be a preferable or equally advantageous means of securing the scheme objectives. Now turn to the Mayor of Cambridgeshire and Peterborough. As we've already noted, the Mayor accepts that if the growth which is planned for Cambourne and Bourne is to go ahead, there is a need for a public transport scheme to serve it. When asked what alternatives, other than the CPPF scheme, are put forward, he said that there were a range of others and went on to say that light rail should be examined. When asked what was the alternative he put forward, he said that we are devising a strategy. He provided no detail of that strategy or any alternative route. This could not have been more clearly demonstrated than in the Mayor's closing submissions. It was asserted that the busway may be incompatible with future policy if the policy is to build a light rail network. The Mayor put forward no deliverable alternative. His suggestions that a strategy was yet to be developed and that light rail may be an option fall squarely into the category of the vague and inchoate to which no or almost no weight can be given. So to conclude on alternatives, given the acknowledged and pressing need to provide a scheme to provide reliable public transport between Cambourne and Cambridge, and given the fact that the C2C scheme would meet that need, in order for a suggested alternative to have a material bearing on the decision-making process in this case, it would have to meet the identified need, be capable of being developed, have significant advantages when compared to the order scheme, such as lower costs or lesser environmental impact, and not lead to undue delay. 4 very important points. Almost all the objectors have relied on the CPPF alternative. It's as plain as it possibly could be that the CPPF scheme is undeliverable. By seeking to avoid unacceptable environmental impacts, CPPF have limited the width of the proposed road and bus lane. In doing so, they have left insufficient width in which to provide a safe scheme. That by itself would be sufficient to reject the CPPF alternative. However, when the CPPF inbound bus lane comes to the part of the network which causes the significant constraint, the existing M11 overbridge, the buses would come to a grinding halt. The CPPF's own witness says that the scheme they advanced is unsafe. So even if, contrary to the evidence, a view were to be taken that the CPPF scheme is capable of being delivered, it would not meet the identified need. It was devised as an interim solution, and such a stopgap cannot be relied upon to support the local plan strategy. So there is no realistic and deliverable alternative scheme, and we invite you to so find. I'm going to hand over to Mr. Henderson, but it might be the right point to take a break.
It is indeed. If you hadn't said that, I would have interviewed in any event. And as we've just interrupted proceedings, Mr. Cambourne, can I just check very quickly 2 things with you as we go along? Can I go back to, please, page 11? Paragraph 37.2, right at the top of the page. What the text says, without a scheme to provide such a public transport, should be reliable, because I think it relates to the previous page.
Should we say a reliable public transport scheme?
A reliable public transport scheme, yeah. Thank you. And the other one, which I had a query about, page 20, and it may be possible that you can read an inference into this, but I just wondered whether at 7.3.2, where it says account taken of East West Rail, and it's a criticism, should it be no account?
Sorry, where are we, sir?
73.2 in the middle of the page. I wondered if there was a missing word. Because it refers to the main grounds of attack.
Yes. Well, you could say no account, but it's the account taken of it, because account was taken within a sensitivity analysis, but they
The way in
say
which account was
it's
taken.
the way in which account was taken.
So do you want the text as it, should it be the text as it is?
Um,
I will,
yes. So how account was taken.
yes. Yeah.
Thank you, sir.
Thank you for those. I'm going to take just 10 minutes today before we resume. So inquiry is adjourned. Back here, please, for 11:30. Mr. Henderson. Mr. Hopkin-Wright, I understand from Mrs. Vincent there's a small point that you need to raise a correction to something that was mentioned earlier.
Date. Committee meeting, 25th of November.
Which concerns the emerging local plan. So it's slightly earlier. 25th of November is the date, and therefore you can advise us of the outcome the following day.
Indeed. Yes, correct. Thank you.
Thank you very much. Mr. Henderson, please.
So thank you. I'll pick up on matter 4, which is on page 41 of
Yes.
the printed closing. This concerns the effect of the implementation, operation and maintenance of the busway. This matter is wide-ranging. All of the relevant matters are assessed in the environmental statement, together with its addendums and the other application documents and the applicant's proofs of evidence. In order to structure our submission on this matter, we've adopted the subheadings set out in the statement of matters, but we've addressed those in a different order. The first is ecology. The issue of ecology is emotive. This is true both generally and even more acutely in this case. Despite this emotion, there is, in fact, very limited evidential dispute about the technical assessment of impacts on the relevant habitats and species. The dispute is confined to veteran trees and, to a much lesser degree, the Coton Path Hedgerow County Wildlife Site. Otherwise, there is essentially agreement on the technical assessments. Veteran trees and biodiversity net gain, one of the other few issues on which there's some substantive technical dispute, are addressed separately, and I'll come on to those. I turn then to the special area of conservation. It's necessary for the Secretary of State to undertake an appropriate assessment of the impact of the busway on the SAC. A shadow appropriate assessment has been prepared. In addition, extensive evidence on the issue of Barbastell bats has been presented by Miss Reason. Drawn on all of this evidence, the correct conclusion is that the busway will not adversely affect the integrity of the SAC for the purposes of Regulation 63 of the Habitats Regulations. Natural England has reached precisely this conclusion following very extensive engagement with the applicant's team, including the review of additional surveys and assessments undertaken at Natural England's request. A competent authority is entitled and can be expected to give significant weight to the advice of an expert national agency with relevant expertise in the sphere of nature conservation, such as Natural England. The competent authority may lawfully disagree with and depart from such advice, but if it does, it must have cogent reasons for doing so. In this case, significant weight should be given to the view of Natural England, all the more so given the extensive and intensive interrogation of the applicant's evidence. There is no cogent reason for departing from that advice. Indeed, no party to the inquiry has even attempted to identify such a reason to depart from Natural England's advice. Mr. Woodfield's position in his written evidence was ambiguous, given at that time Natural England had not withdrawn its objection to the order. However, he confirmed in cross-examination that he did not seek to contradict Natural England's judgment, and, in fact, he considered it unlikely that there would be any adverse effect on the integrity of the SAC from the busway. Despite this, CPPF pursued a narrow argument that the hopovers would not be effective for species other than Barbastell bats. This was a bad argument because the applicant's unchallenged surveys demonstrate a low risk of collision for these other species, even without mitigation. Further, Natural England raised no concern on this point after having considered this very issue in light of the applicant's technical note 2, and the applicant has provided detailed evidence explaining the effectiveness of the proposed hopovers. This position is unchanged by the late evidence relied on by CPPF. The point now made by CPPF appears to be wider and to include Barbastell bats. However, it is still a bad point. The applicant has provided a full response. For these reasons, there will be no adverse effect on the integrity of the SAC as a result of the busway, and the impacts of the busway on the SAC would be acceptable having regard to relevant national and local planning policy. Maddenley Wood SSI. The busway will not have any impact on the SSI. This conclusion is not disputed in any of the evidence presented to the inquiry. Turn then to Coton Orchard County Wildlife Site. In the environmental statement, the applicant assessed a significant residual effect at a county scale on the Coton Orchard County Wildlife Site. This conclusion is not disputed in any of the evidence presented to the inquiry. To the contrary, Mr. Woodfield positively agreed with this conclusion. Despite this, Mr. Woodfield and CPPF spent a great deal of inquiry time on the extent to which Coton Orchard should be classified as a priority habitat. Importantly, this dispute does not go to the assessment of impact in the environmental statement, rather it goes to a much narrower and ultimately incorrect argument about biodiversity net gain. Biodiversity net gain is considered separately in our submissions in a moment, but the remaining submissions now deal with the classification question. The JNCC provides an authoritative definition of the traditional orchard priority habitat. That is, traditional orchards are defined for priority habitat purposes as groups of fruit and nut trees planted on vigorous rootstocks at low densities in permanent grassland and managed in a low intensity way. Crop nut plants are also included. As to that definition, all of the component parts of the definition must be satisfied in order for orchard to qualify as traditional orchard. This is the straightforward and ordinary reading of the definition. When considering this definition and its application, it is the habitat structure which is of crucial importance, not its management, as Mr. Whitby explained. The supporting description makes this point plainly. Habitat structure rather than vegetation, type, topography or soils is the defining feature of the habitat. This is also logical as, using Mr. Whitby's example, an intensive orchard or other non-traditional orchard habitat could be managed in a low-intensity way. This would not mean that the habitat, which was structurally unchanged, could become a traditional orchard within the above definition. And that's particularly apt in this case. Croton orchard is a former intensive orchard which is approaching its end of life. The orchard might now be managed in a low-intensity manner, indeed some parts display no management at all, but its habitat structure is still that of an intensive orchard. The applicant has assessed 0.42 hectares of the orchard, that is within the scheme boundary, as being a priority habitat. As Mr. Whitby explained, this is a precautionary and fair assessment, particularly as some of the included parts were at best borderline, for example in terms of their density. The remainder of the orchard was properly excluded, given it failed to meet the definition, particularly having regard first to the density, which is much greater than the defined 150 trees per hectare, that's every 8 metres. Secondly, the areas which are not occupied by fruit trees, so the hedges, the scrub, etc. And thirdly, the great number of trees which are not planted on vigorous rootstock. The correctness of the applicant's approach, in contrast to Mr. Woodfield's, is exemplified by photograph 1 in Mr. Ellis's rebuttal proof of evidence. The trees on the extreme left are non-fruit hedgerow trees. The trees on the left-hand side are too densely planted and not on vigorous rootstock. They are small but not young trees. And there's an obvious gap between those trees and the priority habitat on the right-hand side. Mr. Woodfield candidly explained in cross-examination that he had not had sufficient time to determine one way or the other as to how each component of the orchard should be categorised, but in any event, there was a clear methodological flaw in his approach. Mr. Woodfield's assessment was based on a strict dichotomy. The orchard was either intensive orchard or traditional orchard. No such dichotomy is present in the JNCC's guidance. Moreover, there is no logic in such an approach. Conceptually, it is entirely possible to have some orchard-type habitat which does not fit the definition of traditional orchard and is not otherwise referred to as an intensive orchard. WSP properly recognised this as other orchard in the environmental statement. Contrary to Mr. Woodfield's assessment, it's not a case of having to make a best fit judgment against only two categories. In any event, even if this was the approach, the best fit is as an intensive orchard given the habitat structure within Croton orchard, as Mr. Whitby explained in his cross-examination. It follows that the categorisation of priority habitat within the environmental statement was correct. However, we reiterate, even if it was not correct, this would only be material to the assessment of biodiversity net gain, not the impact on the Croton orchard as a habitat. Turn then to other county and city wildlife sites. The busway would not have a significant effect on any of the other county or city wildlife sites, that's the Croton Path hedgerow, Bin Brook and the scrubland east of the M11. There was no dispute on the assessment of the latter two city wildlife sites, and nor could there be, given Mr. Woodfield had not even visited those two sites. Mr. Woodfield did dispute the assessment of effect on the Croton Path hedgerow county wildlife site, but his assessment was not robust. In particular, Mr. Woodfield considered the unmitigated impact. This is not the correct approach. Parts from the methodology in the ES, which considers the residual effect, consistently with Regulation 11 of the 2006 rules, which expressly requires mitigation measures to be identified in the environmental statement. Given the statutory direction, it is perverse and inconsistent with the statutory scheme to assess significance against the unmitigated effect. Mr. Woodfield based his assessment of significance on a 1% loss threshold. This is inconsistent with the methodology in the environmental statement, and he was unable to identify a robust basis for such an approach, whether in best practice guidance or otherwise. The one example of this threshold that Mr. Woodfield did identify in cross-examination was materially different to the present case. It concerned bird strikes in a wind farm. and was of no application to a case such as the present. In any event, such a threshold is a blunt tool. The proper basis, as set out in the environmental statement, was to consider whether there would be a loss of any plant species for which the county wildlife site was designated. There would be no such loss in this case. Accordingly, the assessment in the environmental statement should be preferred. Protected and notable species. There will be no significant effects on protected and notable species except in respect of construction impacts on terrestrial invertebrates. As to those terrestrial invertebrates, the significant effects will only be at a local scale and only in the short to medium term during construction. There will be no long-term significant effects and no significant effects during operation. So to conclude on the ecology issue, having regard to the assessment of impacts in the environmental statement and in the applicant's evidence, the ecological effects are acceptable when assessed against relevant local and national policy. Trees. At the heart of this issue is just 3 trees, T6, T7 and T9, being the 3 veteran trees that are centrally located within the order limits. In the context of the scheme as a whole, particularly having regard to the land area which it traverses, this is remarkably limited. The busway will not result in the loss or deterioration of any of these 3 trees or the other 3 veteran trees which are more peripherally located within the order limits, T5, T9 and T10, or the other veteran trees outside of the order limits. In any event, even if there was the loss or deterioration of any of the 6 veteran trees within the order limits, nevertheless a suitable compensation strategy exists and has been secured, and there are wholly exceptional reasons in this case. Route selection. The potential impacts on T5 through to T10 were given express consideration during the route selection process, as documented in the second addendum to the environmental statement. A minor northward shift was assessed so as to avoid the veteran trees, although this would have resulted in a more central route through the orchard. Both CPPF and Miss Daisley were consulted on this option. Neither party supported the northward shift. CPPF identified numerous concerns with this option. The applicant took these views into account and concluded first that the northern option would not provide any environmental advantage over the proposed route given the new environmental effects, in particular new landscape effects which it entailed, and secondly the northern option was also inferior on operational and safety grounds, especially having regard to accessibility, safety, severance, land take and earthworks. Having regard to all of these matters as well as the wider submissions on alternatives which you've already heard, it follows that a robust route selection process has been undertaken, and it's not been possible to avoid the interface with the veteran trees in the orchard. T6, T7 and T9. There will be no loss or deterioration to trees 6, 7 and 9 because they will be translocated. This is Mr. Alder's expert's judgment based on close interaction with the translocation specialist Ruskins, who are experienced in moving fruit trees and have provided an outline methodology which Mr. Alder has incorporated into his translocation methodology. Importantly, the inquiry has not received any other expert arboricultural evidence, let alone any other contrary expert arboricultural evidence. Mr. Woodfield made no reference to this issue in his written evidence, and his throwaway line in cross-examination goes nowhere, given he has no relevant arboricultural qualification, as he confirmed. Miss Daisley unsuccessfully challenged Mr. Alder's evidence. Before we consider her concerns individually, it's important to note first that she is not an arboricultural expert and did not present expert evidence, and secondly, her evidence was not credible, given her claimed reliance on written sources which simply did not exist. This latter point bears greater exposition. In the critical part of her proof of evidence, where Miss Daisley addressed the efficacy of translocation, she claimed that the science is unequivocal and that translocation would result in the loss of veteran trees. Miss Daisley sought to bolster this argument with 2 references, including direct quotation, the first to a research paper and the second to best practice guidance. However, this was demonstrably false. The research paper does not exist. The best practice guidance does not contain the words quoted. Both points were put to Miss Daisley in cross-examination, and she accepted both were inaccurate and did not exist. Whatever the reason for this state of affairs, and it seems that an AI hallucination is the most likely, the end result is that her evidence lacks any credibility and cannot be afforded anyways, either on this issue or generally. Further, and in any event, Mr. Alder explained in cross-examination why each of her concerns was unfounded. In particular, Mr. Alder's evidence is not based on a single case study as alleged, rather it's based on his experience and his interaction with Ruskins specialist translocation experts who have moved hundreds of fruit trees. Whether or not the black mulberry in the case study is a veteran does not change the point that it is clearly a mature tree and of a similar age and size to the apple trees in question. As such, it is an appropriate and informative case study. The fact that Ruskins did not visit the site is of no consequence, given first Mr. Alder's own site visit and tree survey, secondly Mr. Alder's discussions with Ruskins, thirdly the fact that he was able to provide Ruskins with all the information they required, and fourthly the fact that Mr. Alder appeared at this inquiry, was tested on his evidence, and answered all the questions put to him from his expert knowledge. Miss Jaisley's reliance on the emails with Mr. Newman at Civet Trees does not undermine Mr. Alder's evidence. In particular, Mr. Newman did not appear and could not be tested on his views. It's also unclear what, if any, expert qualifications he holds. The weight to be afforded to his emails must be reduced as a result. Despite the applicant's direct and specific request for Miss Jaisley to provide the full series of emails from Mr. Newman, Miss Jaisley declined to provide this information, instead only providing 2 non-continuous emails without any context. There was no good reason for her not to do so. This has 2 effects. First, it undermines still further her credibility. Secondly, it significantly reduces the weight to be afforded to the emails still further. In this latter regard, it appears from the emails that Mr. Newman considered only the Croton Orchard website. Critically, there is no evidence that Mr. Newman considered the environmental statement or any of Mr. Alder's evidence. This is a critical omission in the views expressed by Mr. Newman, and yet another reason to reduce the weight to be afforded to the emails. Mr. Newman also did not inspect the trees himself, again in contrast to Mr. Alder. In any event, there are important differences between Mr. Newman's approach and the relocation methodology presented by Mr. Alder. In particular, Mr. Alder has included an additional pruning event to alleviate impact. Mr. Alder has allowed more time for the translocation. Mr. Alder has included mulching and additional ground treatment and preparation. And Mr. Alder has included an extended period for the guy ropes and a much longer monitoring and maintenance period. In all these respects, Mr. Alder's approach is more precautionary, as Miss Jaisley accepted in cross-examination, and, as such, it is readily understandable why he reaches a different view to Mr. Newman. For all these reasons, and in particular the absence of any contrary expert evidence, Mr. Alder's evidence should be preferred, and the correct conclusion is that there will be no loss or deterioration to T6, T7, and T9. T5, 9 and 10, sorry, there's a typo, so just to be clear, there'll be no loss or deterioration to T6, T7 and T9, and then I'm moving on to deal with the other 3 trees, T5, 8 and 10. They will be retained in situ. There'll be no loss or deterioration to these trees consistently with Mr. Alder's evidence. In this regard, Mr. Alder has provided detailed evidence of the mitigation measures which will secure this outcome, including a draft arboricultural method statement, the final form of which will be secured by condition. There's been no effective challenge to this evidence by any objectors. Timing of relocation. CPPF cross-examined Mr. Alder on a narrow point about the timing of the translocation. There is nothing in this line of questions. The order is likely to be made in 2026. The first root prune will be in the autumn of 2026. And the trees will be translocated at the same time as the third root prune in autumn 2028, after which the busway can be completed. This timing between autumn of 26 and autumn of 28 is consistent with a 2-year build period. The only real delay is in the period between the making of the order and autumn 2026, but this period will be taken up waiting for the challenge period to expire in any event. Further, these times do not make the mitigation undeliverable, as Miss Jaisley alleged in her closing. Compensation strategy. For the reasons we've set out, there will be no loss or deterioration of veteran trees, and thus no need to provide a suitable compensation strategy. However, the applicant has addressed this issue on a without prejudice basis in the event that there is an adverse conclusion on the prior issue of loss and deterioration. The applicant has provided a compensation strategy. This strategy provides compensation on a worst case basis, i.e. assuming loss or deterioration of all 6 trees within the order limits, that's T5 through to T10. A final version of this strategy is secured by condition, and all of the measures can be implemented by the applicant alone, although the applicant remains open to working with Croton Orchard on additional measures. Mr. Alder has explained why this compensation strategy is suitable for the purposes of the NPPF. Wholly exceptional reasons. The applicant has also addressed the issue of wholly exceptional reasons on a without prejudice basis, and we'll come on to address those further in the plan and balance section of our submissions. So to conclude on trees, it follows that the interface of the busway with the relevant veteran trees is in accordance with paragraph 193, subparagraph C of the National Plan and Policy Framework, as well as relevant development plan policy. The impact on the other non-veteran trees is also acceptable when assessed against the relevant plan and policies, and has not been the subject of any particular challenge. T5 through to T10 within the orchard are the subject of a tree preservation order. Taking the TPO at face value and not inquiring further into why it was made, contrary to advice to the local planning authority's officers, this is not a reason for considering the busway to be unacceptable. The TPO only protects the amenity value of the relevant trees. That amenity value will be unharmed, given 3 of the trees remain in situ, the other 3 trees are translocated, and in any event it's compensated for by the additional tree planting. Further and importantly, the removal of trees protected by a TPO in order to facilitate development under a deemed grant of plan permission is permissible, pursuant to Regulation 14 of the TPO regulations. For these reasons, the impact of the busway on trees is acceptable. Biodiversity net gain is the next issue. The busway will deliver a biodiversity net gain of at least 10%. The busway aspires to an even greater gain, but even at 10%, the busway is acceptable and delivers a benefit which should be afforded significant weight in favour of the scheme. Statutory and policy framework. The grant of plan permission for the busway will not be the subject to the statutory condition in paragraph 13, subparagraph 2 of Schedule 7A to the 1990 Act. The reason for this is that the relevant provisions of the Environment Act 2021, which inserted Schedule 7A into the 1990 Act, have not been brought into force for cases such as the present, where plan permission is deemed to be granted pursuant to Section 90 of the 1990 Act, and see the transitional provisions in Regulation 2, and we've given you the full name of the regulations there. Nevertheless, the applicant is committed to achieving no less than 10% biodiversity net gain. That's in line with the Greater Cambridge Shared Plan and Service Biodiversity SPD. BNG at 10% would also satisfy paragraph 187, subparagraph D of the framework, which requires only a net gain, not a particular level of gain. So to the provision of BNG by the busway, condition 15 will secure at least 10% BNG, consistently with the applicant's initial biodiversity net gain assessment. The only change to this assessment was from, only challenge to this assessment was from Mr. Woodfield. Mr. Woodfield alleged that the initial BNG assessment is incorrect on 2 grounds. Mr. Woodfield's first ground was that the individual trees within Coton Orchard had been omitted incorrectly. Whilst those trees were omitted, this is of no material consequence. The trees were omitted as a result of the assessment's timing and transitioning between different iterations of the BNG metric, as Mr. Whitby explained. Earlier versions of the metric did not include the recording of such trees. In any event, the trees will be inputted into the BNG metric for approval under condition 15. Mr. Whitby's explanation is adequate and readily understood. Mr. Parker incorrectly asserted in cross-examination of Mr. Whitby that there had been a failure in the update and validity surveys. This is not the case. As is clear from those surveys, their scope was to identify whether there had been any significant changes in habitat which should affect the validity of the survey data in line with the CIEEM advice note. The validity surveys did not purport to, and thus did not fail to, update the initial BNG metric. Accordingly, the criticism in cross-examination is without foundation. Mr. Woodfield's second ground was that the habitat within Coton Orchard had been incorrectly categorised. That criticism is incorrect for the reasons which I have already explained. In any event, even if these criticisms were correct, they are of no consequence for the following reasons. First, the initial BNG metric is only provisional. A revised BNG metric must be submitted for approval by the local planning authorities under condition 15, following the detailed design of the busway. This mechanism ensures that the final BNG metric accurately reflects the detailed design of the busway and is appropriately scrutinised. Any omissions, trees in Coton Orchard for example, will be accounted for in this final metric. Secondly, on Mr. Woodfield's approach, which is not accepted, the end result is a need to find 51.71 habitat units off-site. If necessary, this can and will be done by the GCP. More particularly, Lower Valley Farm is a very large off-site habitat bank on land owned by the County Council. The site is up and running, it's available to GCP now, and offers 1,000 biodiversity units. This is more than sufficient units, even on Mr. Woodfield's pessimistic assessment of requiring 50 units, and even on the incorrect basis of 910 habitat units being available, as put to Mr. Whitby in cross-examination. As Mr. Whitby explained, Lower Valley Farm has the ability to accommodate all the required habitat and hedgerow units, with the exception of watercourse units. As to watercourse units, the GCP has made provision for units as part of the new Sheep's Green scheme on a watercourse controlled by the City Council. Contrary to CPPF's closing at paragraph 70, the evidence demonstrating the use of Sheep's Green is squarely before the inquiry. The GCP has confirmed that Lower Valley and Sheep's Green will be utilised for GCP schemes first, and only if at least 20% BNG has been attained will units be released to other schemes. Accordingly, there is no risk of these units being used up on other projects. It follows that more than sufficient off-site biodiversity units are available. The absence of any legal agreement is not a cause for concern, as GCP will utilise land controlled by the county or city councils in accordance with its now established approach. Thirdly, it's important to note that Mr. Woodfield's approach is not correct, and none of his claimed obstacles are well founded. Mr. Woodfield's arguments around watercourse units fail as a result of Sheep's Green, and as to the other matters, the calculations undertaken by Mr. Woodfield only assess a snapshot of the busway, namely the off-road component around Coton. This is not a complete assessment of the busway. Critically important components of on-site compensation, for example at Scotland Farm, were omitted. Without the inclusion of such compensation, a fair and objective overall view of the busway cannot be reached. Mr. Woodfield's arguments about the use of new habitats by bats were also in error. The starting point is that, contrary to the later commentary by Mr. Parker, Miss Reason did not conclude that any habitat compensation was necessary. Her proof of evidence was clear. Even in the absence of mitigation, sufficient existing and accessible habitat is available within and beyond the scheme to maintain the favourable conservation status of the bat population given the small extent of habitat loss. In any event, as Mr. Whitby explained, Miss Reason's analysis demonstrates that the busway will result in an on-site uplift in Barbastell bat foraging habitat from 25 to 37 hectares, thus ensuring there will be no adverse effect on the species. There is no difficulty relying on this planting for both the BNG calculation and bat foraging habitat, as there is no requirement for an EPS licence in this case. In any event, as Mr. Whitby explained in cross-examination, there are a number of additional methodological difficulties with Mr. Woodfield's approach. Trees have been wrongly categorised. Further, the extrapolation undertaken by Mr. Woodfield was incorrect. Overall, Mr. Woodfield's approach incorrectly inflated the habitat units required. Fourthly, even if the required biodiversity units could not be found off-site, for example at Lower Valley Farm, it will still be possible for GCP to deliver BNG in accordance with Condition 15 by purchasing biodiversity credits. This is now an established part of the BNG framework. Such biodiversity credits can and will be obtained if required. The only obstacle claimed by CPPF was the cost of such credits. However, this is not, in fact, an obstacle, because even CPPF's worst-case figure of £1 million, put in cross-examination of Mr. Whitby, is a small percentage of the busway's construction cost contingency and not the whole scheme contingency. So to conclude on BNG, for these reasons, the busway will deliver a BNG of at least 10%. The busway aspires to an even greater gain, but even at 10%, the busway is acceptable and delivers a benefit which should be afforded significant weight in favour of the busway and which accords with relevant local and national policy. Carbon. The busway will have a beneficial net carbon impact. The busway will generate a carbon saving of 7,055 tonnes of CO2 equivalent. This calculation is based on the latest F-Series traffic model and uses recent data from the May 2025 TAG data book. Limited positive weight in favour of the busway is to be afforded to this benefit. The criticisms by CPPF. CPPF sought to challenge this conclusion through Professor Hurst's evidence. Two issues were raised. First, the manner in which the data for appraisal years beyond 2050 had been extrapolated, and secondly, the date of the TAG data book used in the original assessment within the environmental statement. Neither criticism stands up to scrutiny. On the first issue, Professor Hurst's approach is directly contrary to the Secretary of State's recent local transport quantifiable carbon guidance, without any good reason. On the second issue, the criticism fails to consider the environmental statement fairly, but in any event it's a matter of form, not substance, and it's a point that goes nowhere. Mr Saunders has presented an up-to-date assessment using the May 2025 tag data book, about which no criticism is now made. Before considering each issue, it's important to note that Professor Hurst's evidence was not expert evidence from a professional witness, rather her evidence was given in support of her personal view in objecting to the busway. Professor Hurst rightly apologised for including an expert's professional declaration. The misleading impression must be corrected. Professor Hurst's evidence must not be considered as impartial expert evidence. On the first issue, extrapolation of data for appraisal years beyond 2050, the applicable guidance for the calculation of carbon impacts in this case is in the section on steam level simple demand forecasting in the QCG. This is very recent and up-to-date guidance published by the Secretary of State in August of this year. As the QCG explains, this method involves extracting linked data from a traffic model for two scenarios, so with and without the busway, applying calculations to estimate carbon emissions, interpolating and extrapolating this over the assessment period, and calculating the difference between the two scenarios. That difference in this case is a carbon saving of 7,055 tonnes of CO2 equivalent. The QCG gives very clear guidance on the approach beyond the year 2050. It states, and I'll read it out, data for appraisal beyond 2050 can be held constant up to the end of the assessment period, extrapolated horizontally, as shown in figure 7.2. Alternatively, the annual change can be between the final two modelled years could be applied before the final modelled year if considered appropriate. So the default option is horizontal extrapolation, where the data for appraisal beyond 2050 is held constant up to the end of the assessment period. See the first sentence of the quotation I've just read out. This is the approach adopted by Mr Saunders. This is the correct approach. The QCG gives an alternative approach, that's in the second sentence of the paragraph I've just read out, starting alternatively. However, Mr Saunders' assessment was, rightly, not based on this approach. This alternative approach was only included in the latest version of the QCG promulgated in August 2025, that is to say, after Mr Saunders' assessment. There can be no tenable criticism for not applying guidance which had not been published. In any event, the alternative approach should only be adopted when appropriate. This is a matter for expert judgment for the assessor. Mr Saunders has explained rightly that this approach is not appropriate. Extrapolation under this alternative approach would imply electric vehicle uptake exceeding 100% before the end of the assessment period, which, to put it mildly, is not possible. This is compounded by the fact that the difference between the last two modelled years is only due to different tag parameters being applied rather than any change in forecast, and thus it would not accurately reflect future trends. Ultimately, Mr Saunders has applied the QCG correctly, even having regard to guidance which was not published at the time of the applicant's assessment. Professor Hurst did not suggest that an approach should be based on electric vehicle uptake exceeding 100% before the end of the assessment period. It follows that her evidence does not support the alternative approach in the QCG. Instead, Professor Hurst promoted her own alternative methodology. This approach was not in accordance with the QCG. Professor Hurst's approach is based on the section of the QCG concerned with the estimation of current and future emissions at an area-wide level without intervention. The assessment of the busway is not such an estimation. The busway requires a project-specific and site-specific assessment with intervention. An area-wide assessment without intervention is of no assistance. This is confirmed expressly in the QCG, which directs Chapter 3 of the QCG, on which Professor Hurst relied, to the strategic planning stage, so for example local transport plans, and instead directs Chapter 7 of the QCG, on which Mr Saunders relied, to scheme development. Again, Mr Saunders, not Professor Hurst, applied the QCG correctly. Re-examination on this point was obviously incorrect as well. Figure 5.2 of the QCG expressly states that for the assessment of preferred options, a quantitative carbon assessment using the guidance in Chapters 6 to 8 should be used, i.e. including the relevant section in Chapter 7 applied by the applicant. Professor Hurst relied on parts of the QCG outside of these chapters and not relevant to a quantitative carbon assessment. There were three further defects in Professor Hurst's approach. First, Professor Hurst's general point about using DFT's common analytical scenarios data, as well as the parts of the QCG that she relied on in support, is in direct conflict with the appropriate and specific guidance on the assessment of a scheme, such as a busway, which instructs that the tag data book is used. There are good reasons for this, in particular the fact that the CAS, the common analytical scenarios is a presentation of many different scenarios of varying probability. Secondly, Professor Hurst erroneously relied on the 2030 ban on the sale of combustion vehicles as a factor supporting the use of CHAS. This was in error because the TAG data book also takes this into account. There is no distinction as claimed. Thirdly, Professor Hurst's approach relies not only on the use of CHAS data, but its application in a straight line until 100% EV car use, at a point which she did not identify accurately, and then horizontal extrapolation thereafter. There is no support for this approach in the QCG. To the contrary, it is an approach which is in direct conflict with the example in the QCG. Professor Hurst's divergence from the QCG was implicitly recognised in re-examination when she was asked whether there were good reasons to depart from the QCG. This argument is hopeless. More particularly, the QCG was promulgated by the Secretary of State very recently in August of this year, August 2025. Accordingly, whilst it is in principle possible to depart from guidance of any age, nevertheless, as a matter of logic, the reasons for departing from recent guidance will need to be particularly strong. This is all the more the case here, given the absence of any material change in circumstances since August of 2025. There is no good reason in this case. It is asserted by Professor Hurst that the applicant's approach is unrealistic, but such a simplistic answer is to misunderstand the nature of carbon assessment modelling. Rather, as Mr. Saunders explained in cross-examination, modelling that far into the future cannot be realistic. The models might be completely accurate, but I just don't know. So whether or not a forecast is realistic cannot be a good reason to abandon the QCG, because difficulties with realism are inherent in all such modelling exercises. What is important is about using the most appropriate forecast, and in this regard the QCG should be followed as its recent guidance from the Secretary of State, formulated with the benefit of expert advice and, critically, directed precisely to the task at hand. Professor Hurst may not like the Secretary of State's methodology, or may consider it has deficiencies, but she's not identified an alternative methodology from an appropriate source. In these circumstances, the methodology in the QCG, as used by the applicant, represents current knowledge and methods of assessment for the purposes of Rule 11.2b of the 2006 rules. Accordingly, by using that methodology, the applicant has provided information which satisfied the legal requirements on the environmental statement under that rule. That was accepted by Professor Hurst in cross-examination. CPPF's submission enclosing at paragraph 45 goes behind that concession, and in any event, even if it were right, it goes nowhere, as it's a criticism of the environmental statement which ignores the totality of the environmental information, including the updated information presented by Mr. Saunders at the inquiry. For all these reasons, the applicant's approach is to be preferred. Accordingly, the busway will have a beneficial net carbon impact. The busway will generate a carbon saving of 7,055 tonnes of CO2 equivalent. The second issue is the date of the TAG data book. CPPF took up a great deal of time at the inquiry on the question of whether or not the correct TAG data book had been used in the environmental statement. This is a line of argument which goes nowhere and is wrong in any event. First, Mr. Saunders has presented an updated assessment in the appendices to his proof of evidence. It is agreed that this assessment utilises the up-to-date TAG data book, namely May 2025. Accordingly, even if there was any error in the environmental statement, which is not accepted for reasons which I'll come on to, it is entirely immaterial, as the corrected assessment is before the inquiry, and the applicant's position, including these submissions, is based on that updated assessment. Notably, the overall conclusion, a minor beneficial effect, is unchanged. Secondly, even if the November 2022 TAG data book was used, as Professor Hurst asserts, it would have made no material difference to the calculation of the environmental statement. Again, the conclusion of a minor beneficial effect would have been reached. Professor Hurst's response on this point was to assert that the November 2022 TAG data book should have been used with the E-series traffic model, but that position is unsustainable. Although the initial carbon assessment in the environmental statement did use the E-series, if an updating process had been undertaken, as Professor Hurst contends it should have occurred, that updating process would not have artificially constrained itself only to one component of the carbon assessment. Rather, it would have utilised the F-series traffic model, consistently with the other later assessments within the ES. Indeed, in respect of Mr. Saunders' evidence, Professor Hurst described the use of the F-series traffic model as acceptable. On this basis, there would have been no material change. CPPF's closing submissions on this point at paragraph 49 adopt the unrealistic position that only a partial update would have been done. Thirdly, and in any event, the approach in the environmental statement was correct. So to the facts, The chronology of events is set out in the applicant's note. CPPF don't dispute that chronology. Mr. Saunders explained in cross-examination that when reviewing the environmental statement during its production, if something had come to pass and it makes a fundamental difference, then you take a view and update it, and that you take a view as to how material it was for the assessment. In respect of the carbon assessment in the environmental statement, Mr. Saunders explained WSP used the TAD data book that was right at the time, changes came to pass, and they took the view that nothing was material. These matters were further explained in WSP's note. In particular, WSP explained that updating to use the November 2022 TAD data book was not a proportionate approach in the circumstances, that traffic modelling derived user emissions were not updated on the basis of proportionality, and that it's not best practice to utilise the forthcoming changes version in advance of the actual updates to the TAD data book. 4 matters are noteworthy. First, as Professor Hurst is not an expert in the assessment of project-level carbon emissions, and as she was not given impartial expert evidence, she is in no position to challenge WSP's explanation of best practice in this area. Secondly, contrary to Mr. Parcher's interruptions in the cross-examination of Professor Hurst, it is apparent from these facts that both Mr. Saunders and WSP provided an explanation of the approach taken, including their view at the time that updating to use the November 2022 TAD data book was not proportionate. Thirdly, it's apparent from the partial update that was undertaken by WSP, that was in respect of the modal shift assessment, that WSP was considering whether to update, and, if necessary, carrying out such an update during the preparation of the environmental statement. This is consistent with the judgments that they have explained. This consistency illustrates why these are not ex post facto justifications. Fourthly, and in any event, even if Mr. Saunders or WSP had not provided any explanation, and or if WSP failed to review the carbon assessment during the preparation of the environmental statement, neither of which are correct assertions, nevertheless it would still remain open to the applicant to explain now why an update to the ES was not proportionate, because what matters is the assessment of the evidence now. This is a further example of why Mr. Parcher's interruptions in cross-examination were incorrect. As to proportionality, the approach to be adopted is set out in the Secretary of State's Transport Analysis Guidance on the Proportionate Update Process, the PUP Guidance. The PUP Guidance explains the following key principles. The TAD orderly release process, for example, that's to say the publishing of forthcoming changes, provides advance notice of changes to TAD. The reason for this process is to give more certainty of timetable for changes and to allow scheme promoters and sponsors to plan the work required to implement those changes. Importantly, this process is not in place to require forthcoming changes to be adopted. The PUP guidance is clear. An update should be made if it is appropriate to do so, not automatically. CPPF's closing submission ignores the inherent judgment in this approach. The decision as to whether an assessment should be updated as a result of TAG data book changes is a decision for the project's promoter based on the principle of proportionality, as scheme-specific assessments require. The applicant's approach, as explained by Mr. Saunders in WSP, was consistent with these overarching principles. Further, the PUP guidance indicates that it is reasonable to presume that the case for not adopting the latest evidence would be stronger if certain matters can be shown. 3 of these matters are clearly demonstrated in this case. More particularly, first, the changes to the TAG data book were not material to the decision at hand. As already explained, even if the environmental statement had been updated, the outcome would have been the same, a minor beneficial effect. Secondly, the risk of successful legal challenge was low. It is untenable to suggest that the wrong choice of TAG data book would have given rise to any legal risk. Any challenge could only have been made by way of a claim for judicial review. No challenge was feasible on this point before the inquiry, given the inquiry provided an obvious alternative remedy. Equally, no challenge is feasible now, as the environmental statement was updated in the evidence at the inquiry. Thirdly, there is no, or at worst only a very low risk of damage to the reputation of the analysis, because first, the reasons for not updating are easily understood, and secondly, it's a matter that has no material effect. It follows that WSP was correct not to update the carbon assessment in the environmental statement, and no proper criticism of this decision can now be sustained. Net emission. Even if the busway is a net emitter, contrary to the applicant's evidence and the submissions I've already set out, it does not follow that the busway is unacceptable for 2 reasons. First, the QCG indicates that a net emitting scheme can be acceptable if the scheme is a strategic fit with the outcomes identified as necessary to decarbonise local transport. The busway is such a scheme because it's an excellent strategic fit with a relevant local transport policy, and that policy is itself focused on decarbonisation. Secondly, it's established national policy and the National Networks NPS that the approval of schemes with residual carbon emissions is allowable and can be consistent with meeting net zero where those emissions will not have a material impact on the ability of the government to achieve its statutory carbon budgets. The National Networks NPS is a material consideration in this case. Mr. Littlewood rightly accepted in cross-examination that the worst case carbon emissions in this case would not have a material impact on the ability of the government to discharge its statutory duties. Accordingly, the policy in the National Networks NPS is complied with by the busway, even in the worst case, and even taking Professor Hurst's evidence at its highest. CPPF's closing submissions tellingly ignore the National Networks NPS entirely. They do so because it provides the real-world answer and aligns planning decision-making to what is realistic. To take a stark example, if a new transport scheme requires to be constructed using embodied carbon, for example concrete, and it's assumed that the scheme will be used by electric vehicles, it will always be a net emitter based upon the formulaic approach. The policy recognises that such schemes, which may be highly beneficial, should not be rejected out of hand. A balanced approach has to be taken. So to conclude on carbon, for the reasons that we've explained, the busway will have a beneficial net carbon impact. This is a benefit of the busway to which limited weight should be afforded in the planning balance, and all relevant development plan and national policies are complied with by the busway. Heritage. When considering any impact on the significance of heritage assets, you will have to consider whether the duties imposed by Section 66(1) and Section 72, subsection 1 of the Planning Listed Buildings and Conservation Areas Act 1990 are engaged. Section 72 of that Act applies to the exercise of any functions under the Planning Acts. Those functions include a decision to make a direction under Section 90, subsection 2A of the TCPA 1990. That planning permission be deemed to be granted. Part of the route of the proposed busway lies within the West Cambridge Conservation Area. When considering whether to make a direction that planning permission be deemed to be granted for that part of the busway which lies within a conservation area, the decision maker is required to pay special attention to the desirability of preserving or enhancing the character or appearance of the area. The position in relation to the duty imposed by Section 66, subsection 1 of the Listed Building Act is less clear. The duty applies when considering whether to grant planning permission. For the purposes of that Act, except insofar as the context otherwise requires, the term planning permission has the same meaning as in the Principal Act, being the Town and Country Planning Act 1990. Planning permission means permission under Part 3 or Section 293A, but does not include permission in principle. It's our submission that a direction that planning permission be deemed to be granted is not a planning permission under Part 3 of the Town and Country Planning Act 1990, as the effect of the direction is to dispense with the requirement for planning permission. However, the planning policy set out in the framework would still be a material consideration and should be applied. Framework paragraph 212 provides that great weight should be given to a designated heritage assets conservation. Generally, a decision maker who works through the relevant paragraphs in the framework will have complied with the duty imposed by Section 66, subsection 1 of the Listed Building Act. We request that you should work through the relevant paragraphs in the framework. If you follow that request, you will have taken account of and applied the policy, and, if it applies, you will have complied with the requirements of Section 66, subsection 1 of the Listed Building Act. The environmental statement, together with the second addendum and Mr. Wilson's evidence, presents a complete assessment of the busway's impact on the relevant heritage assets. Although the inquiry has heard much discussion about the impacts of the CPPF alternative on the American Military Cemetery, there has been no substantive challenge to the applicant's assessment of the heritage impacts of the busway itself. Without prejudice to the full assessments presented by Mr. Wilson, we focus here on the American Military Cemetery and Clare Hall, given they were specifically identified in the Statement of Matters and in the inspector's main considerations. The American Military Cemetery. The American Cemetery is a Grade 1 registered park and garden. The asset is of national and international importance, and as such it is an asset of very high heritage significance. The memorial building within the cemetery is separately listed at Grade 2 star. Mr. Wilson has comprehensively described the significance of these assets and the contribution that Setton makes to their significance without any dispute. the busway would not harm either the registered park and garden or the listed building. This is obviously correct. This is the obviously correct conclusion, having regard to the separation distances, the intervening vegetation and buildings, and the topographical change. Clare Hall. Clare Hall is a Grade 2 star listed building. Mr. Wilson has explained the significance of the building, including the contribution that its setting makes to its significance in considerable detail. Applying the framework, the busway would result in less than substantial harm towards the lower end of the spectrum of less than substantial harm. This harm is only as a result of change within the listed building setting. There will be no direct effect on the fabric of the asset itself. This assessment was agreed by Historic England in its first representation. In its second representation, Historic England did not depart from its earlier representation, but sought clarity on the interface of the busway and Clare Hall along Rifle Range Track. This matter appears to have been noted in response to objections. There is no cause for concern, as Mr. Wilson has explained. The cross-section for sheet 17 is accurate, as it shows the busway adjacent to the Anthony Low building. The busway will not affect the physical fabric of the canal, that's the drainage conduit, including both the original part that is outside of the order limits and the later part that is inside the order limits. With this clarification, there are no matters of concern in Historic England's second representation. Historic England's agreement with the applicant's assessment is unchanged. The heritage balance. Mr. Wilson has identified those assets which will be harmed by the busway. Applying the framework, all of these adverse impacts would be categorised as less than substantial harm at the low end of the spectrum of less than substantial harm. This harm must be balanced against the public benefits of the busway, whilst giving great weight to the conservation of designated heritage assets. Those benefits are explained in our submissions, which we'll come to. Undertaking the balancing exercise, the correct conclusion is that the benefits outweigh the harm, as Mr. Sensical explained. That remains the conclusion, even if the view is taken that the extent of less than substantial harm to Clare Hall is greater than assessed by Mr. Wilson. Landscape. A comprehensive landscape and visual impact assessment has been undertaken in accordance with the best practice guidance Livia 3 and following consultation with relevant stakeholders. No party has raised methodological concerns, although some objectors have contested the conclusions within the LVIA. The LVIA concludes that, first, no significant effects on landscape character are predicted at year 15. Secondly, a significant effect is only expected for 1 out of the 37 visual receptors in the LVIA. That's receptor number 19, users of PROW 55-2. This is a local effect to a short route, approximately 700 metres of the PROW. Thirdly, these effects have been mitigated so far as possible, both during the construction of the busway, in particular through the Code of Construction Practice and the LEMP, and during its operation through the design of the busway and its landscaping. These are robust and correct conclusions. Mr. Littlewood raised a handful of disagreements with the LVIA, but none of these matters were correct, and they did not withstand cross-examination. Mr. Littlewood confirmed that he was not a landscape architect, and that he did not challenge the methodology of the LVIA, which he accepted was consistent with Livia 3. Mr. Littlewood objected to the sensitivity ascribed to the landscape around coating. However, he accepted in cross-examination that the low value ascribed to this landscape was consistent with the methodology in the LVIA and was the correct application of that methodology. Mr. Littlewood criticised the use of LCAs as a landscape receptor because of the physical extent of those areas and, he alleged, the consequential diminution in magnitude of effect. However, when taken to the actual methodology and magnitude used in the LVIA, he accepted that it was applicable to areas of any size. Accordingly, this was another erroneous objection. Finally, Mr. Littlewood's judgment was obviously erroneous, as demonstrated by cross-examination on the views from Red Meadow Hill. This is an identified view in the LVIA. Mr. Littlewood alleged that the busway would appear very obvious and discordant in the landscape from this view. This was not an opinion based on a transparent methodology, in conflict with Livia 3 as he accepted. Further, when challenged on this view by reference to the photo montages, Mr. Littlewood said that a viewer would be unable to see the road, and he accepted that his judgment in his proof of evidence was wrong. It follows that the technical assessment in the LVIA is robust and correct. On this basis, the busway's landscape and visual impacts are acceptable and accord with both local and national planning policy. Greenbelt. The busway is inappropriate development in the Greenbelt. However, its impacts on the openness of the Greenbelt and the purposes of including land within the Greenbelt, including the Cambridge-specific Greenbelt purposes, is moderate at worst, even on a parcel-by-parcel assessment, and much reduced when considered against the Greenbelt as a whole, as is orthodox. Very special circumstances have been demonstrated because the harm to the Greenbelt and other harm arising from the busway is clearly outweighed by other considerations. Accordingly, there is compliance with both local and national policy on this issue. The inappropriate development. The applicant accepts that the busway is inappropriate development in the Greenbelt. The busway is local transport infrastructure which can demonstrate a requirement for a Greenbelt location for the purposes of paragraph 154 H3 of the NPPF. However, there will be some harm to the openness of the Greenbelt and the purposes of including land within the Greenbelt. As such, it is not an exception falling within paragraph 154 of the framework. Harm to Greenbelt openness and purposes. The applicant's Greenbelt assessment has adopted a parcel-by-parcel approach to its assessment, utilising 7 sub-areas. This is a precautionary approach which overestimates harm to the Greenbelt, given the issue of openness is the openness of the Greenbelt rather than the site itself. Even on the precautionary basis, the worst-case effects are moderate levels of harm, confined to 2 parcels, the first including the travel hub, and the second on the outskirts of the city. This assessment was not meaningfully contested by objectors. Notably, Mr. Littlewood positively agreed with the assessment of harm in the Greenbelt assessment on the issue of Greenbelt purposes. As to his wider assessment of harm to the Greenbelt, this was obviously flawed, as demonstrated in cross-examination, because it was based on an earlier Greenbelt assessment undertaken by Luck, which considered residential development, not development akin to a busway. Strategic Greenbelt considerations. Contrary to the view of many objectors, the busway will actually assist in protecting the Greenbelt by supporting the local planning authority's strategic approach. The existing and emerging local plans seek to protect the Greenbelt by allocating land for development, in particular residential development, almost exclusively outside of the Greenbelt and largely beyond the Greenbelt, in particular in Cambourne. However, in order for this strategy to succeed, people must be able to move between their homes beyond the Greenbelt and Cambourne to their places of work in the city. The busway directly facilitates that movement in a sustainable manner, directly supports the local planning authority's strategic approach, and thus protects the Greenbelt. Objectors also raised concerns about the busway causing inappropriate development within the Greenbelt. Such concerns are not well founded, as demonstrated in the cross-examination of Mr. Littlewood. Any future development in the Greenbelt, for example in and around Coton, will be the subject of a separate development management process. This decision-making of the local planning authority is an intervening stage and means that there is no direct relationship between the busway and future inappropriate development in the Greenbelt. To the contrary, if development is facilitated beyond the Greenbelt by the busway, such that a sufficient supply of land can come forward to meet the area's needs, then it's likely to be easier for the local planning authorities to resist development within the Greenbelt itself. Very special circumstances. We addressed the very special circumstances balance below in our submissions on the overall planning balance, but for the reasons we'll come on to explain, the harm to the Greenbelt from the busway as well as the other harms arising from the busway are clearly outweighed by the benefits of the busway taken as a whole. As such, very special circumstances have been established, and there is compliance with local and national planning policy. Without prejudice to the full plan balance exercise, it's important to note here that there is no alternative which avoids the Greenbelt. The CPPF alternative does not avoid the Greenbelt. Any public transport scheme to connect Cambourne and Cambridge in an efficient way needs to traverse the Greenbelt. The fact that such public transport improvements are encouraged, and in fact required, by both adopted and emerging development plan policies illustrates precisely why this issue is not a showstopper, and why, unsurprisingly, the very special circumstances balance lies in favour of the busway. The delivery of the busway through this part of the Greenbelt directly serves an important strategic objective of planning policy. Flooding. There was no meaningful dispute on this issue following Clare Hall's withdrawal. The busway will not give rise to any significant flood risk effects. The adverse effects will be negligible. The busway complies with both local and national planning policy, in particular the sequential test, if it applies, and the exception test. The majority of the busway is located within flood zone 1, but a small area in the eastern extent is located within flood zone 3. The flood risk assessment identified potential impacts to flood risk in 3 areas: smaller watercourse crossings, increased surface water runoff, and the Bin Brook crossing. The effects on smaller watercourse crossings and surface water runoff are not controversial. Assessment has shown that the crossings of smaller watercourses will not result in any increased flood risk, and assessment has shown that there will be no increase in surface water flood risk to the surrounding areas or the busway itself. In this latter regard, Mr. Southern also explained why Mr. Sadler's concerns about land drainage, which are principally a concern about impacts on existing land drains, will not give rise to any increased flood risk. This is consistent with the assessment in the environmental statement, which concludes that there will be a neutral effect on land drains. In practical terms, it's also important to note the swales and drainage features which will be installed on both sides of the busway as it traverses the Sadler's land. Turning to the Bin Brook, the applicant has undertaken extensive modelling of the potential effects. This modelling has been extensively interrogated and reviewed by the Environment Agency over more than 2 years. The end result of that process is that the EA has withdrawn its objection and concluded that the model is appropriate for the assessment of the busway and is sufficiently robust to support the FRA in meeting the framework's requirements on flood risk. Based on this modelling and the FRA, the evidence presented by Mr. Southern has demonstrated that, firstly, the busway will result in only very minor increases in the extent of flooding, with all of those increases contained within the order limits. The EA agrees with this conclusion. Secondly, the busway will result in minimal changes in flood depth. There will be a minimal increase in flood depth in channel, being only a 0.8% increase. There will be a similar pattern of out-of-bank maximum modelled water level. These increases are within the order limits. Outside of the order limits, there will be minimal reductions in flood depth in areas that are already inundated. The EA agrees with this conclusion. Thirdly, on this basis, the busway will not increase flood risk elsewhere and will be safe for its lifetime. Again, the EA agrees with these conclusions. The advice from the EA should be given significant weight and followed unless there is a cogent reason not to do so. There is no such reason in this case, and none have been suggested by any remaining objector. Accordingly, this application should be determined on the basis of the conclusions set out in the applicant's evidence and agreed by the EA. Turning to the sequential test, recent changes to the PPG, the Plan and Practice Guidance, mean that the sequential test does not need to be applied because the applicant has demonstrated, and the EA has agreed, that the busway will be safe for its lifetime and will not increase flood risk elsewhere. In any event, even if the sequential test does apply, it is passed, because there is no sequentially preferable alternative at the eastern end of the busway. As Mr. Southern explained in his examination in chief by reference to the flood mapping in his rebuttal proof of evidence, the alternative route along Adams Road would pass through areas at the same risk of flooding, both on the corner of Adams Road and Grange Road when travelling east, and also further to the west, immediately south of Charles Babbage Road. Finally, the exception test is satisfied by the busway. As we'll come on to explain, the busway will provide wider sustainability benefits to the community that outweigh the flood risk. In particular, improved public transport options through the bus services on the busway, improved travel by sustainable modes, both through the buses on the busway and by foot and cycle on the maintenance track, and as a result of the modal shift which the busway will deliver. The busway will be safe for its lifetime, taking account of the vulnerability of its users, without increasing flood risk elsewhere, as already explained and as agreed by the EA. For these reasons, the effect of the busway on flood risk will be acceptable and in accordance with both local and national planning policy. Noise. There was no meaningful dispute on this issue following Claire Hall's withdrawal. Through the environmental statement and Mr. Lewis's evidence, the applicant has presented a robust and precautionary assessment which concludes, first, that there may be significant effects during construction at 3 locations. However, this is a worst-case scenario with multiple levels of inbuilt precaution. In particular, the baseline monitoring was conducted in areas considered representative of the lowest sound levels that would occur, and the construction assessment assumed unrealistically prolonged and intense periods of activity. Moreover, mitigation will be secured through the COCP and the LEM. All operational effects will be below Lowell and Seoul, such that no adverse effects at all for the purposes of paragraph 198 of the framework will occur, and this outcome is secured by condition 34. On this basis, the noise effects are acceptable having regard to local and national planning policy. Air quality. The busway will not give rise to any significant effects during construction, so that's dust, PM2.5, PM10.5, NO2, or during operation, again, NO2, PM2.5, PM10.5. Although the construction impacts will be adverse, the ES concludes that the effects will be negligible, short-medium term, temporary and not significant even on a cumulative basis. Operational effects will be mixed, with both beneficial and harmful effects, but overall will be beneficial. 3 times as many receptors will experience a decrease in concentrations of NO2, PM2.5 and PM10.5 as would experience an increase when comparing scenarios with and without the busway. This overall beneficial effect is as a direct consequence of the busway, in particular as a result of modal shift, and is not as a result of other unrelated changes in fleet composition, etc. This is a benefit of the busway. Although Mr. and Mrs. Burford have raised specific concerns about their property, which we'll come on to address, those concerns do not change this overall picture and are not based on any technical evidence which contradicts the environmental statement. Overall, the busway will deliver an air quality benefit to which substantial weight should be afforded. The air quality effects are acceptable in regard to local and national planning policy. Local residents, pedestrians, cyclists and motorists next. Generally, the busway will deliver benefits to local residents, pedestrians, cyclists and motorists through the transport benefits as well as the wider benefits which will be delivered. We deal with those benefits comprehensively below in our submissions on the planning balance. Some objectors have raised specific concerns about impacts on pedestrians and motorists in and around Coton. These concerns are not well founded, as was demonstrated in cross-examination of CBAG. More particularly, on footnote 55.2, the applicant has surveyed the footpath in a robust manner. This survey shows very low levels of usage in June, so the summer when walking is most attractive but still term time. Most of this use was on a weekend. Assessed objectively, it is not well used and there will be no impact on school children, if any in fact use the route, particularly having regard to the provision of an at-grade junction and the future ROGS safety process. Access onto Maddenley Road. The study area for the transport assessment includes all roads within Coton, including the junction of Cambridge Road and Maddenley Road. The transport assessment did not identify any unacceptable adverse effects on this junction or any of the junctions within Coton when modelling the future year with the busway. Concerns about antisocial parking are unrealistic, given first the stops in major residential locations near Coton, such as Cambourne, Bourne Airfield and Hardwick, which will mean that local residents can access the busway more easily than by driving to Coton. And secondly, the park and ride facility with ample car parking. Turn now to deal with objectors who've raised specific objections based on amenity or on impacts to their properties, which we've not addressed elsewhere in our submissions. Mr. and Mrs. Burford. Mr. and Mrs. Burford raised a specific concern about the impact of dust and emissions to air on Mrs. Burford's health. The evidence before the inquiry does not support this concern. The principal risk is during the construction stage. As to that, the applicant has undertaken a specific dust risk assessment which considers all human receptors within 350 metres of the order limits. The Burford's property falls entirely within this assessment area. Accordingly, they have been considered as receptors in the risk assessment. In addition, a modelled assessment of emissions to air has been undertaken. 3 receptor locations were close to the Burford's property. Neither of these assessments identified any significant effects. The dust risk assessment identified only a low risk to human health, and the modelled assessment of emissions identified only a negligible impact. In addition, Mr. Saunders explained that a comprehensive package of mitigation measures, including a future specific risk assessment for the Burford's property, had been secured. In particular, Condition 8 requires submission and approval of the COCP, which must substantially accord with the draft Code of Construction Practice. This secures all of the mitigation measures considered in the environmental statement. In addition, Condition 9 requires submission and approval of the LEMP, including sections 4 through to 13 of the draft Code of Construction Practice. These sections include monitoring by qualified environmental management staff, both in respect of soil stripping specifically and air quality more generally. Further, if the local planning authorities consider it necessary, Condition 3 provides control over the location of the haul road, see Parts 2 and that's Roman 2 and Roman 5 sub B, such that the location to the south of the order land and thus more than 100 metres from the Burfords' property can be secured. The Burfords have relied on the Equality Act 2010 in their representations. The applicant does not concede that the provisions of the Equality Act apply to the decision maker in this case, i.e. in the decision to make an order under Section 1 of the 1992 Act and to issue a direction under Section 90, subsection 2A of the 1990 Act, or to the applicant as promoter and distinct from the applicant as operator. The applicant also reserves its position as to whether Mrs. Burford falls within Section 6 of the Equality Act. However, these submissions assume that the duties in Section 20 of that Act on which the Burfords rely do apply, and assume that Mrs. Burford does fall within Section 6 of the Equality Act. The duty to make reasonable adjustment comprises of 3 requirements set out in Section 20, subsection 3, subsection 4, and subsection 5 of the Equality Act. A decision to make the order and to issue a direction granting planning permission would comply with all 3 components for the following reasons. Firstly, as to Section 20, subsection 3 of the Equality Act, there is no provision, criterion, or practice which puts Mrs. Burford at a substantial disadvantage in relation to the busway in comparison with a person who is not disabled. As explained in the applicant's evidence and set out in the submissions I've already made, there would be no unacceptable adverse impact for any human receptors, including Mrs. Burford, as a result of the busway. Secondly, as to Section 20, subsection 4 of the Equality Act, Mrs. Burford's concern is about dust and emissions, not any physical feature for the purposes of this provision, and as such there is compliance with this duty. Thirdly, as to Section 20, subsection 5 of the Equality Act, Mrs. Burford's concern is not about the provision or non-provision of auxiliary aids, and as such there is compliance with this duty. It follows that even if a duty to make reasonable adjustments arose, that duty has been complied with in this case. Dothway residents. The Dothway residents were specifically concerned about flooding to their properties. However, as we've already explained in our submissions, and as Mrs. Fry accepted in cross-examination after being shown the relevant documents, the busway will not increase flood risk for Dothway residents. Mr. Baker. Mr. Baker is also a Dothway resident. Unlike Mrs. Fry, he maintained his objection, notwithstanding the applicant's evidence and the views of the Environment Agency. He was unable to articulate a robust basis for maintaining this objection, and he was unable to provide a cogent reason for departure from the advice of the EA. Accordingly, his evidence does not undermine the acceptability of the busway in terms of flood risk. Ashcroft Vets. Ashcroft Vets object to the proposal to remove a lay-by near their premises at 169 St. Neots Road. The applicant considered this objection and proposed a solution which would allow a lay-by to be provided to facilitate deliveries. When he gave evidence, Mr. Tomovich said that the provision of the lay-by and the other measures set out in the letter would overcome his objections. The solution proposed by the applicant can be delivered without making changes to the order. East-West Rail. The effect on land safeguarded for East-West Rail is identified in the Secretary of State's Statement of Matters, given that East-West Rail Limited now propose a mined tunnel at Cambourne, and thereby avoiding any risk of conflict with the busway, and have withdrawn their objection. Such impact is no longer a matter of concern. East-West Rail Limited are strong supporters of the principle of the busway project and see it as being aligned with the objectives of East-West Rail. It is clear from East-West Rail's limited position and from the emerging local plan that the order scheme and East-West Rail can be seen as complementary projects. The order scheme will have no adverse impact on East-West Rail. There are other issues now, so one on the ES and secondly on the Water Framework Directive. You've heard submissions from us on both of those matters in the roundtable session and separately, so I propose not to read those parts out, not least because nobody else has raised a particular issue on either point, but they are there to assist you in compiling your report. So that takes us from paragraph 327, if we take as read 327 all the way through to 337, that deals with those 2 matters. I'll then pick up at paragraph 338, and that's to conclude on matter 4. The reasons we have set out in these submissions, the applicant submits that the effects of the implementation, operation and maintenance of the busway are acceptable. We describe further below in the submissions, which we'll make shortly, the particular benefits that the busway will deliver for users and local residents. Then on to matter 5 briefly, that is the effect on statutory undertakers, statutory utilities and other utility providers. The busway will not have an adverse effect on statutory undertakers, statutory utilities or other utility providers, or their ability to carry out their undertakings effectively, safely and in compliance with any statutory or contractual obligations. Protective provisions have been incorporated into the draft order where necessary. There is no objection from such undertakers and there is no substantive dispute under this matter. That's matter 5 and Mr. Cameron will pick up on matter 6.
Right, so as you're swapping over again at this stage, and we've made reasonably good progress, I suggest this is a good time for the lunch adjournments as it's approaching 1 o'clock. Would it cause any inconvenience if we have a shorter lunch break? I had in mind about half an hour today.
Fine by us, sir.
Right, in that case, the inquiry is adjourned. We'll resume at 1:15.